Hello, everybody. Oh, Billy, did you learn the trick? Mwah. Billy got a bath today. And yes, Eileen and Carlin, I thought of you. And I tried to get a picture of him wrapped up in a towel, but he was an extra spicy burrito. He wasn't a fan of that idea. So that didn't happen. You want one of these no rawhide rings? She really loves those. I'm fresh out of my shower, so yeah, I thought I'd come on a little bit earlier. And I realized as I was blow drying my hair, trying to rush myself to get here on time, even though I was allegedly 2 minutes late, allegedly. I realized I never hit export. So that's going right about, now. And yeah, we're going to live through it. We're going to make it. Hello, Wire Mother. Hello, Manny. Well, you can complain. I found every time I complain, nobody really cares. But you can still do it. Hello, Nana Laura. Hello, Michelle Moreland. Hello, Jerry Matthew Boyd. Hold on. I'll throw you a life vest. Get it. I hope you feel better. I hope I can at least make you smile. Oh, I already said hi to you. Let's see here. Hello, Eileen and Carlin. Hello, Linda Applegate. I am so excited. So excited. Where did I see it? There it is. Okay. Yeah. I got a gift. I got a gift from Linda Applegate. I was just trying to find the open spot. Oh, just a minute, Ava. I'll get you more. Just give me a moment. Mama's trying not to stab herself with the scissors here. Linda Applegate did a fantastic job of taping this up. Oh, for crying in the mud. Okay, the box is gonna just get demolished. Oh, first off, get his. That was so perfect, Earl. Get his. Oh, I love that. He's looking at me like, what the heck, lady? Okay. On to the main source of my happiness. Linda Applegate sent me pennies. There's 4 rolls of pennies here. And then she sent me an extra special little treat. Oh my. Oh my. Oh, that's gorgeous. So there's this. That's beautiful. Thank you so much. And then, oh, a perfect non-circulated wheat penny from 1956. That is in, well, it's maybe not non-circulated, but it's in uncirculated condition. Oh, that's beautiful. I was just checking to see if it was a proof. It's not a proof, but it is gorgeous. Oh, I wish I could get the detail on there. It is just superb, but unfortunately, I can't show. Oh, it's hot in here. I just got out of the shower, so I'm a little warm, fresh from the shower. Okay, and then, oh, look at this. Oh my gosh. I can't believe the quality. That is absolutely amazing. And then my favorite coin of all, my absolute all-time favorite coin of all, the 50-cent pieces. So there's 2 $50. And then a 1982 dime for my birth year. Ooh, another wheat penny from 1944. Ooh, a 2024 penny. No way. Thank you. That is and it's in like pristine condition. That is a superb find. Oh my gosh. An absolutely beautiful Canadian penny in gorgeous, like near pristine condition. Absolutely beautiful. Gosh, I wish I could show you guys better. And then, no way! You've got to be kidding me, Linda Applegate. It is. It's a 2025. I don't have one yet. Well, at least not that I know of. But I mean, I've got a lot of pennies to go through, but I haven't found one yet. Oh my gosh. And then there's a 22. There's an 82. Ooh. There's something special about that too. And then a 23. Hold up. It's hard to see, you know. It's hard to see. So I got to get a good look at it. Okay. So from a distance, it looked like there was something funky about the two, but under the microscope, it's not funky. Linda Applegate, I am so unbelievably grateful. This is amazing. I love them. I love them so much. Hold on, let's check his ear. Let's see if there's doubling on Lincoln's ear. I don't think so. Earl, you're not exactly helping. He does have, there's a little bit of a niche behind his ear. So there is a little bit, I'll have to look at that a little bit closer, because there is a little bit of a niche behind his ear. But I'll have to compare that to other pennies. It's hard when you're looking at one at a time and you haven't looked at them in a while. But let's see if we get a good close up. You can see the people on the steps. Penny from my birth year. Thank you so much. Oh my gosh, I love them all. And that moment with Earl. When I threw the paper. That was priceless. That was absolutely priceless. Oh my gosh. I destroyed the box. But that's okay. The kitties have plenty of boxes. Oh my gosh. My elbow pad dropped. Whew. It's warm in here. Excuse me. I'm surprised Ava didn't come back for her final third treat. Shh. Maybe she'll forget about it. Hello, C-Rex. Oh, she didn't forget. Hi, you want to come out? You don't get treats when you're under there. She sure didn't forget. Hello, Charlie, my sweet brother. Hello, Buzzy Pug. Hello, Joey Big of Donuts. She just got her third. That's 3. Hello, Tony. Welcome. Hey, now. That should be the free space. just the sweetest. You are just a doll. I don't think that was my fault. You were messed up when I found you. Hello, Edie Weedy. Thank you so much for being here. Hey, hey man, I gave Billy a bath today. I I think, I accomplished something. That's a huge feat. Hello, Wolf Lore Lover. How you doing, sweet thing? Hey, you and your little nose nudges, they're the cutest thing. They really are. They're just the cutest. Well, this is my sparkle shirt. My brother gave it to me, and it's gorgeous. I love it. It's one of my absolute favorite, softest, warmest shirts. Hello, Amanda Roderick. Thank you for being here. Go lay down on the couch. Go lay down. Good girl. Guess such a good girl. Let's see if we can do this without making any noise. No, no. No, go over there. Ava, go over there. Ava, go over there. She's such a goofball. I did not. It landed next to him. Oh, that's adorable. That had to be so fun. I can't wait to see it. Yeah, no kidding. Oh, I'm so happy. I am so happy, joy. I can't even get them from banks anymore. I'm so happy. I love them. I love them so much. I love all old money. I do. I love 50-cent pieces are my favorite. They really are. They're my absolute favorite coin. But I love coins indiscriminately. I am going to put all of these into a special container. I have just the thing in mind too. It is uncirculated. I wasn't 100% positive because typically uncirculated things, only 50-cent pieces that I've been looking at. So oftentimes they'll have this type of baggie on them, but that's not always the case. I love this. It's so gorgeous. It's so shiny. And that 2025, that's definitely going in a sleeve. That is getting absolutely protected. Sleeve and book. I am so happy. Bye, Earl. Hello, Spider-Man. You know, in Florida, it's so cold that iguanas are falling from the tree. You could get a free meal that way. I've never had iguana. I've never. When someone I love sends it to me. It's so weird. Like, there's so many different things that make coins special. It'd be impossible to go. Like, there are books this thick that have, all of the different pictures with years and key dates and things like that. I could talk about it for hours on end. I'm not even kidding you, and not cover even the basics. But the biggest thing to look for is what's called doubling. Um, so when the press comes down, I think it's that it slides a little. I think I might be wrong on that. I can't remember. It's been a long time since I looked it up. But doubling happens, and you'll see um, distinctly, like, a letter on top of itself, kind of like it'll look like you hit the copy button, and it copied just a tiny bit down and or to the side. Sometimes it's extreme, sometimes it's barely visible. But even on the barely visible ones, it can be quite lucrative. I mean, you can get $3 or $4 for a quarter. Yeah, it's crazy. And here's the other thing about it. It's the only hobby that really truly costs you nothing. You go to the bank, you get however many rolls of coins you want. Let's say you go in with $10. Get $10 worth of coins. Go home, look at it, pick out, the couple that are gonna sell, whatever's got doubling or key date or whatever you're looking for. And then take the others back to the bank. Rinse and repeat. It never costs you anything. It's still money. Oh, I love it. I love it, love it. I had a much more powerful one before this one, but when I got it, it had a tiny little black dot on the glass of the scope inside. And they were trying to tell me that, like, it was something I did. Like, how? Right out of the box, it's got this black dot, and they're like, "Oh, well, what did they said it was, I can't remember, but I know my argument to them was that if they were correct, then when I rotated the picture and took a rotated picture, the dot would move. I think it was that they were telling me it was on my coin or on the slide or something. And I'm like, no, because when I rotate the image and take the picture again, the dot's in the exact same place. So that argument doesn't hold. So I sent back the super powerful one, and I had seen reviews anyways that said that you don't really want the super scientific microscopes. My daughter wanted one, but she's in college. She's got plenty of them at her disposal. So yeah, I traded it in for this one, which is absolutely fantastic. I love it. I love it. I have a manual one that has a little light, and then you got to, like, make the mirror aim, to get the right light source. And then, it's a Encyclopedia Britannica one, I think. but it's a kid's microscope. But it did well for, before I got my digital one. I really wanted one that I could hook up to the computer and then, you know, project onto the screen. Unfortunately, that didn't happen. The software just doesn't, it's not compatible. So it is what it is. Oh, I already forgot it. Forget what? Honey, you've made me so happy. I can't thank you enough. I am so truly grateful. You guys are all so amazing and you're so, so sweet to me and the animals. I just couldn't ask for a better life. No. Thank you. I knew they were super, super shiny. They are going in sleeves and then in the book. All right, let me see if I forgot anybody. Zoom through here. Zoom, 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 zoom. Ah! Hello, Mortimer Duke. How you doing? Yeah. I'm special like that. I mean, you should see what I do for a nickel. Oop, oop, there's Earl. Hi, Earl. Manny, I hope you feel better. I'm so sorry that you're in pain. Hey, Earl. Let's see if he does it. Earl. Human. Human. He doesn't care. He's half got the zoomies right now. Tickle your pickle for a nickel. Okay, guys. I'm gonna put the cases on. Oh, we're gonna have fun tonight. We are gonna have fun. Keep those comments flowing because with being on a little bit earlier, it's going to be accessible to a wider audience. I know it's only, a couple hours early, but still there's, more people online now than there are at 1:45. And the more y'all make comments, the more y'all talk, then the more YouTube deems the stream worthy.
Afternoon, everyone.
Good afternoon, Your Honor.
Hey, Miss Reda, can you hear me okay? You're on mute, ma'am. You're on mute. You need to unmute.
There.
Okay, I can hear you now.
Okay. Good afternoon.
Good afternoon, yes, ma'am. Okay, well, today we are here on the motion to quash filed by the defendants. And yeah, I think that's it. So I've read the motion, I've read the response in opposition to the motion. And I'd like to get on the record with some argument. Let me see, what else needs to be addressed? It was just that and the protective order. Okay. Everyone ready to go on the record? Yes?
Yes, ma'am.
I'll take that as a yes. The court calls cause number 2025 DCV 4280, Sylvia Dominguez Reda versus the Coral Police Department. May I have announcement of council, please?
Yes, ma'am, Your Honor. Eric Britton here on behalf of Defendant Socorro Police Department.
Okay, good afternoon, and let the record reflect that Mrs. Sylvia Reda, Dominguez Reda is on as well. We are conducting this proceeding on the Zoom teleconference program, and we're doing so in compliance with the Texas Rules of Civil Procedure. Additionally, this is being broadcast live on the YouTube channel of the 41st District Court in compliance with open courts provisions of the United States and Texas constitutions. Ms. Bertha Prieto is the official court reporter for this proceeding. Her transcription will be considered the official record. No other transcription or recording from the Zoom teleconference or the YouTube channel will be considered the official record. And let the record reflect that I am presiding over this matter while physically located at the El Paso County Courthouse. As I stated this afternoon, we're here to consider the defendant's motion to quash, which was filed on November 17th, 2025. It's an objection to the subpoena issued by the plaintiff to the defendant for records. And I understand, Mr. Britton, that you are also asking for a protective order. You may proceed on your argument.
Yes, ma'am, Your Honor. So just for timeline, the lawsuit was filed by Ms. Reda on September 24th, 2025. So the Socorro Police Department was named as a party, answered, and appeared in the case with its answer and affirmative and verified denials. The subpoena was issued on October the 30th. Pardon me. The subpoena was served on October the 30th, 2025. So a little over a month after the lawsuit had been on file, and was served, importantly, on the defendant, the Socorro Police Department. A copy of all that has been attached for you as an exhibit to the motion. The bottom line is, Your Honor, we're not for a second contesting that the plaintiff is not entitled to the documents, but she's gone about it the wrong way. Number one, a subpoena cannot be used on a party to circumvent the rules of civil procedure. Rule 176.2 provides that a subpoena may not be used for discovery to an extent, in a manner, or at a time other than provided by the rules governing discovery. So we've got, first of all, you can't conduct any discovery until your initial disclosures have been exchanged. The plaintiff has still not provided initial disclosures. The subpoena was served on a party. The subpoena did not have a time for compliance. The subpoena, if you look at it, asks for, quote, documents on Sylvia Rueda, narrative police / Sierra policeman report, witness involved, reconstruction unit / special unit, BAC testing, and Detective Frias Friday. So basically, again, it's untimely. It should not be able to issue a subpoena on a party to the case to circumvent the rules of discovery. The subpoena itself, we have to guess what's being asked for. For example, documents on Sylvia Rueda. It doesn't say documents pertaining to the accident of September 30th. So basically any document with her name on it, with the Socorro Police Department. And as you know, the proper party actually is the city of Socorro. So any document that has her name on it from the city of Socorro is overbroad, fails to specify the documents or categories of documents sought with reasonable particularity. The narrative report, Sierra policeman report, arguably asks for every report ever filled out by Officer Sierra, which would be overbroad, global, not limited in time or scope. and would seek information which is neither material nor relevant to any issue in this lawsuit, nor reasonably calculated to lead to the discovery of admissible evidence. The reconstruction unit slash special unit, I'm not sure what she's asking for. Presumptively, it's documents that would have been generated by one of those units to the extent such a unit exists. The BAC testing, again, not limited to time or scope. Is that asking for every BAC test ever performed by the Socorro Police Department on any individual? And then Detective Frias Friday, I don't know what's being asked for.
Okay.
And so that was basically the reason for seeking alternatively the motion to quash. And then, of course, the protective order, just to ask that although the discovery that she requires, that she be allowed, again, send us requests for production that are properly worded and reasonably limited in time or scope, but simply not in the fashion or the way that she's attempted to do by circumventing the rules of discovery.
All right. Mrs. Reda, I did review your response. I'm not sure if you were able to capture all the nuances of the points made in the defendant's motion. There are legal objections to the use of a subpoena in this instance, under these circumstances, and in the way you did it. So I'm going to let you respond to what Mr. Britton just said. Maybe you can elaborate a little bit more than what you provided in your response.
Okay. First of all, I did write a date, which was September the 30th, 2023. And I did write, because I do remember what I wrote on the subpoena. Yes, I did write, which was Officer Sierra and Detective Friday, because they all these individuals were involved in that particular incident. So I do remember, and the reconstruction and the special unit slash, because it's the same entity. I mean, it's the same thing, reconstruction slash special unit. It's the same thing. BAC was a blood alcohol content that the Socorro police did not obtain.
Wait a minute. You subpoenaed the blood alcohol content that the police did not obtain? Is that like when you order something and you don't receive it and you contact the company and they say, "Can you send us a picture?" That's the item right there. Like, how do you produce something that they didn't do? So they don't have. I get that she's pro se, but she has a fool for a client.
During that incident. So all these factors that defendant talked about, they're all listed there. So I'm just asking for the limited evidence that will help my case move forward. And according to this, my case does not move forward because they don't allow, I can't go there to Socorro. I cannot obtain those documents, which will help me,
Right.
proceed
Okay.
the case. But I do need all those evidence, probably the way I went, specifically, but I did write the date, and it was around 2:00, which I probably did not write the time, but it was a date. and it was, those officers were involved. Detective Friday was involved because he was the one that would go to my house. And I told him about, the incident involved. There was a witness, and apparently, if you look at the police report, there's a witness, there's a witness. However, when I went to when I went and talked to Chief Robles, he declined. He said, "Oh, there's no witness no more." So everything that I asked for that particular date, because I did an internal affair complaint, I think before this, and I talked about them. I told them, I mean, why did they not help me? And then he said, well, that individual does not work here no more. This does not work here no more. And I barely received a written statement, barely yesterday, from the Socorro police, that they're doing everything, that they have done their share.
Okay.
That
So did you got a letter or a record of the underlying accident that you're talking about?
no, I got a letter
A
that
letter,
they're
okay.
saying,
So let me just tell you, I have the subpoena. I have the subpoena, and Mr. Britton did attach it to his motion. I believe you have a copy of it, correct? It's Exhibit C to his motion. And it says that you are sending a subpoena to the Socorro Police Department, and then you list one, two, three, no, 1, 2, 3, 4, 5, 6, 7 separate things. And and here are the problems with it. Maybe if I just break it down to what the problems are, just so you know. So, because I'm gonna grant the motion to quash the subpoena, but I want you to understand why. First, when somebody files a lawsuit in the state of Texas, the parties, both sides, have to engage in what's called discovery. And as I said at the beginning, you are responsible for understanding and applying the rules of procedure and the rules of evidence. And there's a whole section on discovery on what you can do and what you cannot do, when you can do it, when you can't do it anymore. All those things that have to do with discovery. And that's the way litigation controls how the parties exchange information. I give you my stuff because I'm required to do it. You give me your stuff because you're required to do it. And that's how it's controlled. The communication between the two parties is controlled. And that way you both know what the other one has. And then if they don't turn it over, then they can't use it later. They can't hide it. You can't hide things. And it's intended to also kind of narrow the issues. What are the issues involved in this case? Instead of it being like this generic lawsuit, the discovery helps both parties understand what you're fighting about. So when you issue a subpoena to a party in the case, in this case, it's Socorro Police Department, which is part of the city of Socorro, you cannot use a subpoena. You have to use the discovery tools that are allowed in the rules. A subpoena goes to an outside entity, not a party that you need information from. Like, for example, say Life Ambulance responded to the accident. Life Ambulance isn't part of the city of Socorro. They're an independent company. You subpoena their records. You subpoena non-parties. That's issue number 1. Issue number 2 is you need to be very clear on what exactly you are asking for, not just like all records regarding Sylvia Reda. Well, that could be all sorts of things. And it's not just the city of, the Socorro, the Socorro Police Department, it's the entire city of Socorro. And there's all sorts of things out there that might have your name on it. So it's not very specific on what you're asking about, and it can't be everything under the sun. It has to be something that leads to relevant evidence in this case. So like, say, for example, you bought a house in the city of Socorro, and then the city of Socorro has records that you bought this house 30 years ago. Well, there's a record on Sylvia Rueda, but that doesn't have anything to do with this lawsuit. So you have to be very specific, and you can't just give people's names. Like, what about that person? What do you want about that person? So you have to be very specific. And then you also have to give, did she go away? Did we lose her? Miss, okay. Can you hear me, Miss Reda? You need to unmute.
Yes, I,
Okay, so I can go on and on with examples. So I'm gonna quash the subpoena. I'm just explaining to you why I'm gonna quash it. And we've talked about how it's your responsibility to follow the rules on this. And so I'm gonna go ahead and quash it because it doesn't meet it's not allowed under these circumstances. And then for all the reasons stated that on things that are even wrong with it,
I think she's walking a fine line because she's not actually telling the defendant what to do to remedy the situation. She's only telling her why she loses.
you need to put in a little bit more work into it. No.
okay, I
Okay.
understand.
Okay, so
Yes.
I would still encourage you, again, I told you this the last time, try to find either legal counsel or a lawyer who can give you like a little summary of advice or something that you can pay for, because things will only get more complicated. The issues that are presented in this case, I can already tell, are going to be very complicated. And so if you could, and you seem like a very smart lady, you know a lot of stuff that even sometimes lawyers don't even know. But so I'm not suggesting that you can't handle litigation. I'm just
Sylvia, I assure the judge is fluffing you.
saying that in this particular case and in a district court, it gets very complicated. And I just want you to be able to do it right if you need, to get to where the point you want to be. But okay.
I understand.
Yes, ma'am. Thank you. So, Mr. Britton, I'm going to go ahead and grant your motion. If you could send me an order. And we do have a status conference set on April 30th, 2026. If you need some time before that April date to consider any other motions, and this goes to both of you, if you need court time before then to consider a motion and you need a hearing, just let me know, and my coordinator, actually don't let me know, let the boss know. Let Mr. Uri Baron, he's the coordinator, and he can give you your court time. Okay? Anything further, Mr. Britton?
Okay.
Your Honor, do you want me to send the proposed form of order to Ms. Rueda or simply send it to the court?
Just go ahead and send it. If you could just send it on Word, though, in case I need to tweak it a little bit, it'll be helpful.
Yes,
And just go ahead and send it, and I'll make it of record. Miss Reda, you're gonna get a copy. Once I sign it and file it, I'm gonna be the one that files it. You're gonna get a copy on the email, okay? Okay. Anything
Okay.
further, Miss Reda?
My second step right now, which I know I shouldn't tell you, but I'm gonna ask for a projection from him. I'm gonna try to schedule an appointment, a meeting with a defendant.
You're meeting with a defendant. Okay, you can't do that without Mr. Britton,
So
without going through Mr. Britton. Because they have
I know.
a lawyer.
I'm gonna try.
Oh, you're gonna get in
Yes.
touch with Mr. Britton to arrange it? Oh, okay.
Yes,
I understand.
yes.
Okay, all
Okay,
right.
thank you.
Then you do what you need to do. All right,
Okay,
thank you both for your time. I appreciate it. Have a good rest of your day.
thank you.
Thank
You
I
too.
be excused.
Yes, sir. Thank you. Mrs. Reda, thank you.
Be excused.
Your Honor, can you hear me now?
Yes, sir. You're on.
Sorry about that.
No, no problem. Thank you. Okay. Are we waiting on anyone else?
Well, Your Honor, I think Mr. Almeida thought it was in person, so he's there outside the courtroom. But I'm not sure we need him for the hearing.
Okay. I'd like to give him the ability to observe. I can't set it up in the courtroom for them, but
If he can participate, if he can just listen here on the phone.
yeah, and I can also send, Woody says we can. My coordinator says we can set it up for him in the courtroom. Woody, can we do it quickly?
Yes, Judge.
Mr.
Yeah,
Almeida.
Mr. Morales,
Yes,
tell
I'm
him
sorry.
tell him that he's gonna go into the courtroom and he's gonna watch it on the screen.
Mr. Almeida. Señor Almeida. Sí, que entre a la corte y ahí le van a dar puedes verla en la televisión, ¿eh?
Sí, ya vino un señor y
Ok. Gracias, ¿eh?
Ok.
Adiós.
No, gracias.
Bye.
Bye.
Your Honor.
Okay. So, are we ready to go on the record?
Mark Winton's facial expressions throughout this hearing just crack me up. Every time I look at him, it's hilarious. Like his aside from the case, his facial expressions just they are just grand.
Yes, Your Honor.
Yes, Your Honor.
Miss Bertha, are you ready? Okay. The court calls cause number 2025 DCV 5187, Ruben Dario Almela versus the Promised Land Holdings LLP. May I have announcement of counsel, please?
David Morales for Mr. Almeida.
Mark Winton for the Promised Land Holdings LP, Your Honor.
Okay, good afternoon. Let the record reflect that we are conducting this proceeding on the Zoom teleconference program, and we're doing so in compliance with the Texas Rules of Civil Procedure. Additionally, this is being broadcast live on the YouTube channel of the 41st District Court in compliance with open courts provisions of the United States and Texas constitutions. Ms. Bertha Prieto is the official court reporter for this proceeding. Her transcription will be considered the official record. No other transcription or recording from the Zoom teleconference or the YouTube channel will be considered an official record. And let the record reflect that I am presiding over this matter while physically located at the El Paso County Courthouse. This afternoon, we're here to consider the defendant's special exceptions and 91A motion to dismiss that was filed on January 27th, 2026. And the basis of the motion is the plaintiff's third amended petition, which was filed on January 22nd, 2026. We had a hearing on the 20th. We had some discussions about the concerns we were having with the plaintiff's petition, or that the petition that was current at the time. And so here we are today with this new hearing. Additionally, if this matter survives the motion to dismiss under Rule 91A, we will have a temporary injunction hearing on the underlying matter. So I've received the motion, Mr. Winton. I've read the motion, but I'll let you proceed now with your arguments.
Yes, Your Honor. If it may please the court, first and foremost, just to restate on the record on that hearing that occurred on the 20th, I believe, our special exception was sustained at that time. That order has not been entered in the court's filings, but it was sustained in the record. Also, that occurred in that hearing was that Mr. Felipe Aguirre was dismissed from the case. So, and basically, we've gone through this. This will be in effect the fourth time now. Whereas plaintiff's pleading, it still continues to miss the basics, Your Honor. And part of what the court directed plaintiff in that last hearing was that if they did not address those issues in the sustained special exception, was dismissed with prejudice. Again, like where do I start? We are missing fact and we are missing law, which allows this court to be able to grant plaintiff's request. First and foremost, their own petition basically pleads themselves out of this case. Their newest petition, the third amended, has basically it's a trespass to try title. And their claim in equitable interest is saying that they're saying that, hey, court, declare that defendants don't own the property, but also declare that we had an agreement and I get to buy it from them. So how is it that you get to declare that defendants don't own anything, but order that thing for which they don't own to me? So by its very definition, the court cannot grant what they're asking because the plaintiff is asking for you to give something for which they also claim the defendant does not even own. So on that very basis, on their trespass to try title and quiet title claim, they can't ask for something that they say doesn't exist. Now, they also, under trespass to try title, there are potentially other ways in which they could go about this. They have alluded to the fact that there is another owner here, and yet that owner is not mentioned. So just on the basis of what they're pleading, what they're requesting, it literally doesn't make any sense, and they can't even be granted what they own. So that on its base under the 91A is why it should be dismissed. Now, in terms of what this petition is missing and what it's missed from day one in the original pleading, the first amended, the second amended, and the third amended. So we're here on the fourth amended. We still are missing the who, what, when, where, and why. They're saying we had an executory contract, and yet there is no. What was the term? What is the interest rate? What are the payments? When does this start? When does it end? I mean, there's literally nothing. And they attach in their own exhibits to their pleading a lease agreement, signed by plaintiff. And they say, in their own affidavits, they say this doesn't, a lease doesn't exist, and yet they attach a lease. So the who, what, when, where, and why of plaintiff or defendant deserves fair notice under 45 and 47 as to the who, what, when, where, and why of the whole thing, which still is missing since day one. And then now to this, theory of ownership, they have attached a deed with the name Harry Lauer to it, and they're saying that's the original owner. Okay, Judge, these guys don't own anything, that's the original owner. And yet that person is not named as a party. That person has not been cited to appear. In addition, that own Exhibit B for which they attach, it has, it's not even within the chain of title for this property. It has a whole other legal description. So the other issue is that we are missing, proper identification of parties. So we talked about this on the First and Second Amendment about whether Mrs. Aguirre needed to be joined to this. And in the last hearing we had, we discussed it multiple times. It either needed to be, you join both Mr. and Mrs. Aguirre, or you get rid of Mr. Aguirre and you just go against Promised Land. And in that last hearing, Mr. Aguirre was dismissed. And now we have him again back named. And we also have named wife, but even worse, we don't even have her name. If you look at plaintiff's pleading, there's a bracket, wife's name. It's 4 times in their pleading, wife's name. It's even more comical, Your Honor, because if you go and look in the clerk's, the case search, and where they list the plaintiff, it literally says wife's name Aguirre. Like, even the clerk is like, well, who? Because there is no name entered. So we clearly need to identify all the parties, and wife's name Aguirre is not a party. And additionally, the property address. So we know whenever you're trying to, quiet title, or perform a trespass to title, you should provide the property. Well, again, in brackets on plaintiff's third amendment position is property address. The property is not identified. And to me, it reads as an AI, fill in the blank, draft me a thing that was not reviewed. And we're missing parties, missing the property. And so to that again, so if we give plaintiff all the benefit of the doubt and go look at all the exhibits reference 3 different parcels. So in Exhibit A, which is plaintiff's affidavit, which in itself contradicts their own pleadings and their own, what they've alleged, says 2.5 acres located at 15548 Union Avenue, Clint. Okay, that's one. Then they attach Exhibit B, which is, I guess, purportedly to show that there's another owner. And that one says the south half of the northwest quarter of the northwest quarter of the northwest quarter of Section 19, Block 7, Public School Lands, El Paso County, Texas. Second property. Then we have, they've put affidavits as Exhibit C, affidavits of adverse possession. One of those says, 231 Horizon Avenue, 30, 13 to 15, which I would interpret as Lot 13 to Block 15, Block 231 Horizon City Unit 30, 10,802 square feet. And there's another one which effectively is the same thing, which is 2.4794 acres. So we have in effect 4 different potential legal descriptions in the attached exhibits on plaintiff's petition.
That in itself could be a problem, along with wife's name Aguirre.
And we have a property address in brackets, like this was a template bought off the internet for which someone needed to fill out later, which obviously wasn't filled out because it's missing. So what property are we even here for? Fair to join indispensable parties. So again, are we joining Ms. Aguirre? Are we joining Mr. Aguirre? Are we sending citations? Are we trying to get them served? We kicked them out, we brought them back in. What are we even doing there? And then now Mr. Lauer, Harry A. Lauer, so are we saying he's the original? So are we doing a trespass tri-title against him? And if we are doing a trespass to tri-title against Mr. Lauer, they actually haven't pled any cause of action. So trespass to tri-title, there's all different subversions of that. There's color of title, there's under adverse possession, there's under common ownership, there's under, and they've not pled any of that. Their petition is absent a way for this court for which to render any relief on them against Mr. Lauer, and he's not been joined. And then additionally, motion to deposit funds in the registry of the court. Which way is this? If it's a purchase and they're pleading executory contract, well, guess what? All of those payments, well, those are payments for the property. You don't get them back. So why would then you get the property and you get your money back and we didn't own it? I mean, that literally makes no sense. And then after plaintiff filed their petition, they then file a memorandum of law, which the court has not asked for any clarification on anything. And a memorandum of law can't, clear their original issues. So, Your Honor, we have gone in circles, and from day one, it was name the parties. Parties have been failed to name 4 times now. Parties have been dismissed and brought back in. We now do not have the property named. I mean, at some point, when does this end? Because, I mean, how many attempts do we get at this, would plaintiff get at this, which is why we request this to be dismissed with prejudice, and we want attorney's fees. And at this point, I'm currently, less this hearing, 11.58 hours into this, about $3,500 in my time, for which my client is paid for. I mean, Your Honor, at what point, I guess I'm just at a loss. I'm kind of frustrated because I have no issue, Your Honor, with duking it out over the facts, over the law. But when we can't even get the parties named, I don't even know what to say. I'm a bit flabbergasted.
Okay,
Could I, Your Honor?
thank you. Mr. Winton, are you finished?
Yes, Your Honor. I'm sorry.
Yes, sir. Thank you. Mr. Morales, you may proceed.
Your Honor, with respect to the parties, I mean, it's obviously clear that here we've having non-suited Mr. Aguirre, Felipe Aguirre, that the party here is Promised Land that claims to be an ownership. Now, Mr. Winton seems to ignore the fact that we started this whole situation with an eviction case. They filed Felipe Aguirre versus Ruben Almeda, and they named the petition there in JP Court on May the 14th, 2024, in JP Court, that was 6 or 2. And there they identify the property, Your Honor, that's in question. That's Horizon 231, Horizon City, and the like. We both know which property they're talking about. In fact, Mr. Uh, Winton presented photographs of the property saying that it wasn't a homestead, that how could anybody live there?
Mr. Morales, let me stop you. Okay, let me just hone in on what my responsibility is. This is a 91A motion, and I have to make the decision on whether I need to dismiss this claim based on your petition, not extraneous things like what happened at a JP eviction case or other evidentiary issues. It's on the four corners of your petition. And so what we all both know, I mean, I can't make those assumptions without them properly being pled. You started by saying you had non-suited Mr. Felipe Aguirre and that the proper party was was Promised Land Holdings. That may or may not be true, but you've included him in your current new petition.
Well, Your Honor, the inclusion, when he mentions like the blank, the wife and the like, those are in the statement of facts. They're not,
They're not. It's not in the statement of facts.
what's he referencing now? The plaintiff's third amended original, the one that I filed on January the 22nd,
Correct.
right? So the only named defendant there is Promised Land Holdings.
Well, at the top, and then if you look at the body, it says paragraph 2, Promised Land Holdings. Paragraph 3, defendant Felipe Aguirre. Paragraph 4, defendant wife's name Aguirre.
Well,
And
the
then
thing, but
so you name these two individuals throughout your petition.
but
And
it's
so
in the
just, sorry, go ahead.
But it's in the statement of facts, Your Honor. The special exceptions here is based, one, is there fair notice of what the issues are? When we file reduce that argument to a quiet of title, it's not necessary to bring Mr. Louder into the question. The court has to decide who has and who does not have a claim on this property. And we're arguing here is that it may turn out that even Mr. Almada may not have claim to the property because after all this process, Promised Land or Mr. Aguirre never had ownership by adverse possession because they just can't do it by simply filing things with the county and saying, I take over this property, it's mine. You know, Mr. Almada has just the same right to do the same thing. That's what this litigation is about, is to decide who has title to this property. I don't have to, at this point, argue that Mr. Lauer is dead. Now, what's happened here was, and it's relevant, Your Honor, because it's relevant to his estate, because it might be that the court decides, you know what, Promised Land doesn't have a valid claim to this property. Therefore, if they didn't have valid claim to this property, they shouldn't have been charging Mr. Almada, entered into a rental agreement or a purchase agreement and received payments in behalf of for this land because it wasn't theirs. These are all things to be litigated. I think it's clear from us. We want a quiet title suit because we can argue all those issues. We need a declaratory statement that the defendants do not own it. Defendants do not own that property as of 2008. No valid landlord-tenant relationship was ever existed because they didn't own the property. Defendant's adverse possession affidavit does not convey title. That's something to be argued, Your Honor. Defendants lack standing to evict plaintiff because they're not the owners. They don't have a rightful superior ownership because they have no ownership interest in this property.
But we're
So
not here, Mr. Morales, we're not here on an eviction. We're not
I
here
know,
on
but
eviction.
we're
We're here on very distinct causes of action that I think you're attempting to allege. And the question today, right now, is not whether I have to decide who owns it or doesn't own it. The question here under 91A is whether you have pled a proper justiciable issue with fair notice. I'll read to you the rule. A party may move to dismiss a cause of action on the grounds that it has no basis of law or fact. A cause of action has no basis in law if the allegations taken as true, together with inferences reasonably drawn from them, do not entitle the claimant to the relief sought. A cause of action has no basis in fact if no reasonable person could believe the facts pled.
Your Honor, I
That's
don't know.
what we're trying to point out to you is then this, obviously the special exceptions have to do with the inclusion of the necessary things for notice. So it's two different mechanisms that your petition is being challenged. Not whether your client should win or lose. That's not where we're at. I haven't heard or seen any evidence, and you proffering it and arguing it and providing me a brief in support of it is so premature. We are way ahead of it. All we're talking about is your petition. Again, this is the style the third amended petition, but I think it was said that there was actually the fourth. I can count them
Your
if
Honor,
you
I
want,
don't
but
understand.
it's your latest petition.
I don't understand what I'm lacking here. I am pleading the what would be statutory requirements for a quiet title, for declaratory judgment, for fraud and by non-disclosure. Fair notice, Your Honor. I think Mr. Winton knows that they have fair notice. We're questioning whether they have a right to possession or not.
And
I
what
mean,
Mr. Winton knows or doesn't know is not what I have to base it on. I have to base it on your petition. So when you say, for example, paragraph 8, section 3, property at issue. This suit concerns the real property commonly known as bracket property address, El Paso County, Texas, the property. So, and then it says more particularly described in Exhibit A. And if you go to Exhibit A, it's referencing your client's affidavit that talks about an address at 15548 Union Avenue. If you keep going on your petition about referencing various other referencing the property at various other points, if you look at defendants special exceptions on page 4, it outlines that you've actually described 4 different pieces of property. So what you assert we know, or I know, or we all know, whatever, that's not the standard. The standard has to be your petition under 91A, under the rules of the special exceptions. So that's just one thing.
Well, when they very clearly are using a template form for their pleadings and not filling them out, or copying and pasting from previous hearings. Like, this guy's a lawyer, allegedly. How do you do this? I I, as a layperson, know better than to include 4 different properties in my one motion. And not to just leave address here in empty brackets or paste the wife's name here. He either used AI or he used just a generic template from online.
So anyway, that's kind of where we're at. So if you can tell me not what Mr. Winton knows or doesn't know, but tell me if I'm reading this correctly, how your petition can overcome this motion to dismiss and how can it can overcome the special exceptions that have been pled.
Well, you are obviously you have to ignore the fact that this whole situation originated in eviction court. You want to ignore that. The fact is they were trying to evict my client from a specific piece of property that they know that they're arguing exists. I filed suit to quiet title, right? So that's something that I believe is to be argued. If they want to argue that in court as to what property is at stake, I mean, I can then
That's
offer
your
evidence.
burden. You're the plaintiff. That's
Well,
your
Your
burden.
Honor, that's the thing here is that I'm not suing here in a vacuum. The bottom line is that I offered a deed here is an exhibit that exhibits exactly the property that's involved. That's a warranty deed by Mr. Lauer. That's the same thing that they reference, Your Honor, in their exhibits when they claim by adverse possession, they send notice that they are claiming adverse possession from the piece of property that was owned by Mr. Lauer. I'm using their same evidence, Your Honor, that they presented. It's clear, but only unclear because they're trying to, in essence, avoid accountability for what they're doing. But I mean, I can understand that. I believe probably I'm at fault here because I might have this filed a draft instead of the actual thing, but it should not be clear. It's fair notice, Your Honor. They know they've got problems here. My pleadings are to quiet title, right? In a quiet title, I'm putting into dispute who is the owner. They're arguing that they are the owner. Last court session, Your Honor, he was vehement about arguing that he had the right to evict because he had the superior right of possession. And I said, well, let me then let me change the suit here to a quiet title suit. I'm arguing that they don't have ownership of the property. I'm arguing that we have ownership of the property. I'm arguing that they don't have ownership because their effort to gain ownership through adverse possession is defective. It's not in compliance with the law. Therefore, I think I have a viable argument there. Now, can the court grant me that? Yes, you can. You don't have to declare my client owner, but you can declare that they're not the owner. You can declare that their paperwork, their adverse possession affidavits are defective and do not grant them ownership. Therefore, without that ownership, they have no right of possession, a right to evict. Because, Your Honor, this is where it's headed. This is going. They're trying to get out from under this court because they want to go back to JP court to evict my client from where? From a property they already stated in their petition in JP court. They gave the legal description of the property. Now that it have different addresses, well, that's the nature of that property in those areas, Your Honor. But I don't see where I have failed to give them proper notice. I'm arguing that they just don't have the right to own that property.
What, did he seriously just claim that it's the nature of the properties in that area to rotate addresses? Because he didn't get it right on his motion? What? That's this guy's a lawyer, allegedly.
And therefore, the question here is, are they denying that my client paid 17 years of monthly payments? And they're saying, well, who has the right to that property? If I'm asking the court, can you decide whether they have ownership or not? And if they don't have ownership, Your Honor, then they don't have a right to that money. They have to put it into the court registry, where then eventually it can be decided as to whether they're going to keep them. Maybe that money's going to wind up in the estate of Mr. Lauer, because neither one of us have the right to that property. The court can decide that. You don't have to decide who does Promised Land or Mr. Almada have rights to that property. You could say, you know what, the estate needs to, that's where that money's going to wind up. It could go to the state, whatever they call that fund with the state of Texas, where dead people's monies wind up. So I don't see, Your Honor, where I have failed here. I've argued quiet title. I've argued declaratory judgment. I've argued fraud and fraud by non-disclosure. I've argued constructive trust to protect perhaps the interest of Mr. Lauer, and I'm looking for injunctive relief.
I've thrown the spaghetti at the wall, and damn it, none of it's sticking. It's all just falling to the ground. I'm out of spaghetti. Seriously. I gotta get all these straws. This guy's a loon.
What is missing here, Your Honor? I mean, it's these are, if he's that experienced in this law, he should understand these are typical standard arguments with respect to disputes over title.
Yeah, I can tell you that part of the difficulty for me is me making sure that I'm following the rule, because you keep switching theories. You have done that over the last several hearings on your petition. You keep switching the picture you're trying to paint in order to avoid the eviction. And so as I keep trying to remind myself now also, is that under 91A, I have certain parameters that I have to consider. But you keep repeating how you're trying to avoid an eviction. You keep repeating that maybe your client doesn't own it, but the defendant doesn't own it, so they can't evict your client. You keep repeating how that you're trying, they don't own it, therefore they cannot evict your client. Part of the conversations we've had, and I just want to say this for the record, is that you have included the lease agreement. In previous hearings, you have said how it doesn't matter if it's a lease or a sale. Your point being that the defendants don't own the property to take any adverse action against your client, regardless of whether it's a lease or a sale, which makes me believe, like, well, was it a lease or was it not? And that's not what you're pleading, and that's not what you say
Your
over
Honor,
and over again.
you're using my arguments against myself because you're getting into the weeds of the evidence while
I'm
saying
not.
while I'm saying I'm moving
trying
back and
not to.
forth.
Let's just say that. I'm
Well,
really trying not to. I'm trying to conform to 91A and the rules on special exceptions and your elements on what you would need to state a claim, what you would need to give notice about, and whether you've properly pled them. I can tell you that blank spaces on properties, on 4 separate references to 4 different properties on your exhibits is not helpful to overcome a 91A motion,
Well, the question is
regardless of
whether
what we
it's
all quote
fatal,
unquote know.
whether it's fatal to the argument or not, Your Honor. The question here is that they themselves in their pleadings have made reference to a specific property. They claim as a matter of defense that they have adverse possession of what? They've described a property, right? That they have adverse possession. They submitted an affidavit saying that on 2008, I, Felipe Aguirre, claim I'm the owner of this property. What property? The property that's in question. In 2017, they make call for a transfer of property from Aguirre to Promised Land. What property? They describe the property. That's the
And it's
property
not
that
the property. It's there are different descriptions. So that's kind of giving me a little pause. I know you make reference to them from your pleadings. You reference the content, but they have different descriptions, first of all. But anyway, Mr. Winton, you wanted to say something?
Yeah, a couple little points. We've pled nothing. We didn't file the petition. We have filed a general denial. We haven't even gotten to the point where we plead or argue or put our counter arguments. So number one, we've pled nothing. Number two, other than general denial, we've also not submitted any documents, any evidence. I mean, everything that we're discussing here has been submitted by plaintiff. Like, we've not even gotten there yet. So putting those words in our mouth, what we've pled, what we've claimed nothing. We're not even there. Number two, Mr. Morales said something actually that I think may bring clarity if he'll understand his own statement. We are not in a vacuum. Actually, that's exactly what we're in. Every court case is a vacuum where all these outside things, the court puts all those out and you bring your case, you bring your facts, you bring the law, right? And that's what makes it an independent tribunal outside of all these other things. I mean, the judge may personally despise me as a human being, but she's going to put that aside. I'm making a joke. Hopefully the judge doesn't. But, a judge would put those things aside, right? And just look at the facts and the argument. So we are in a vacuum. And that's why all this is so critical, because it's not what anyone supposes anyone knows. It's what's pled and the evidence and all those things, which we don't have. And again, too, what Mr. Morales is arguing is he has no standing to argue. He's saying Promised Land does not own this property. It's between Promised Land and Mr. Lauer. Well, guess what? A third party does not have any grounds for which comes to declare whatever arrangement I may or may not have with Mr. Lauer, or my client, Mr. Lauer, as invalid. They don't have standing to do that. They have only standing to bring their claims against defendants. And what they've brought against us is a claim that cannot be satisfied, that cannot be addressed by this court. And they're asking for ownership of a property. And they've not brought it against, anyone that can be satisfied with based upon their arguments.
Well, who's Promised Land? We're saying you don't own it. If you own it by adverse possession, then we own it by adverse possession.
No,
Yeah.
we're claiming you have a lease. And again, under a
No,
lease
no,
and under
no,
all of this,
no.
hold on, let me get
Your Honor, the thing
No,
is that we
hold-
have a right to argue that even in a written so-called rental agreement, if they are not an owner of that property, that rental agreement is invalid. We have a right to prove that. We
Sir,
go into
on the
court and
rental
present
agreement,
the
have
evidence
you
and
read
say,
the rental agreement?
Hold on. You can't speak
No.
over yourselves, and you can't speak to each other. You're addressing me. You cannot speak over each other. I think I've heard enough of the argument. I think I need to, again, my job is to have proper application of the 91A rule to the motion to dismiss. I have a question on whether it can be done with prejudice. I have to be clear on the special exceptions. I'm not going to give another opportunity to amend after several tries. I think I went beyond fair on postponing some of these decisions, but this is your best and final, and I have to take it as such. and review your petition as such, as your best and final. So, I need to make the decisions based on the rules. Now, so I'm not going to take any more argument, is my point. On the defendant's, plaintiff's motion to, let me see what it was called. There was also, I don't necessarily have it scheduled for today, but I want to point it out that there.
Mr. Morales is thinking this is like an Oprah moment. You get a property, you get a property, you get a property too.
There's a motion to compel a county and deposit funds into the registry of the court. This motion was filed by plaintiffs on January 23rd, 2026. I think, I want to say contemporaneously with, oh no, it was the next day, the day after the amended petition. That I've read through the motion. I think there's no basis in law to do that at this point. And so I'm gonna just summarily deny that motion. So I have a disposition on that as well. I don't need to read arguments, hear arguments. I've reviewed some of the authority cited by the plaintiff, and it's for the most part inapplicable. So I'm gonna summarily deny that motion. I'm gonna make a ruling on the motion to dismiss and the special exceptions, hopefully before the end of the week, by tomorrow, I guess. And then that'll tell you where we stand once I issue my motion. If it survives the motion to dismiss and the special exceptions, this matter will be set for a scheduling conference in about, I don't know what routinely we do, about 2 months. And during that time is when you engage in discovery and those things. Until I rule, I'm hoping by agreement that we won't move for the execution of the eviction petition
Yes, Your Honor.
until I have my ruling. Mr. Winton?
Yes, Your Honor, you have my word.
Okay, as an officer of the court, I'll accept that as true. And I think it's an important part to preserve pending the ruling on your motions and special exceptions.
Yes, Your Honor.
So then, Mr. Morales, is there anything further?
Well, you said not to argue anymore, Your Honor, so I guess I'm done.
Okay, all right then.
I
Mr.
would like to ask you, and I'm sorry.
Yes, sir.
I'm going to, I don't know whether you want a motion or not, but I'd like to make sure that depending on your motion, if it's the motion to dismiss, I would like some findings of facts and conclusions of law to be afforded us so we can consider whether, because this will bring an end to this conclusion that I'm just going to simply appeal to the 8th, and I need those findings of facts and conclusions of law. I think my client has filed an affidavit of inability to afford court costs. Therefore, I'm also asking for a transcript of this hearing and the prior hearing so that we can submit that in there with our appeal.
Okay, well, let me start there. That is something that you discuss with the court reporter. She can guide you on the rules on when a person who's indigent can get a copy of a transcript. Offhand, I don't know what the rules are. My best expert would be my court reporter.
Okay.
And if not, we can investigate that for you. On your request for findings of fact, you would need to, first of all, you would need to make a motion for such, and then I would rule on whether I would agree to do so or not.
Okay.
But when you have a 91A motion, I don't make findings of fact. I cannot make findings of fact, especially if you're asking with regard to your underlying dispute on the property, on the agreement, lease agreement, sale agreement, whatever any of those things are. I'm not making findings of fact because I haven't heard evidence to support any facts. My ruling on the 91A motion should comport with the rule, and that should give you sufficient indication on your points of appeal if
Okay.
needed. If
Thank
needed.
you.
Yes, sir. Anything further, Mr. Morales?
No, that's it, Your Honor. Thank you.
Yes, sir. Anything further, Mr. Winton?
My only request to the court is in our motion, we have asked for either the 91A or the enforcement of the original special exceptions to dismiss with prejudice. Our goal, Your Honor, is the dismissal with prejudice. Whichever route leads to that is what we're seeking, just for
Okay.
clarity. We've asked for either or, and that's the reason why. So whichever on the rule can result in the with prejudice is and you know the reasons. Everyone knows the reasons why.
He doesn't care about anything other than this lunatic not being able to refile and him being able to just be done with this nonsense and not have to go a sixth time around.
All right,
Well,
and that's
hey,
one
you
of the
say you know
points.
everybody knows the reasons, but there's nobody wants to go on the record as to why I'm getting dismissed. See?
I'm not dismissing. I told you I haven't made my rulings yet.
Okay.
And then with a separate legal question for me is, would I, if I would dismiss, would it be with prejudice? So I haven't made a decision yet. So let's not cross or assert that's the where we stand. Mr. Winton, what I'm understanding is that you just want clarification that your first choice would be a dismissal with prejudice.
Yes, Your Honor, whether that's through a 91A or enforcement of the special exceptions.
And
Okay.
just for the record, Your Honor, I would select if you don't want to accept the pleadings as they are, we should not be barred from pleading, coming back and pleading properly. So we don't want to get dismissed with prejudice. It should be
Right.
just a dismissal.
Right. And that's what I'm going to check to see what the scope of my authority is with that question. All right, so if there's nothing further, at this time, we are adjourned.
Thank you, Your Honor.
Thank
Your
you.
Honor.
Have a good rest of your day.
Thank you for me to be dismissed.
You too. Thank you.
I know that it was a slow start, but by golly, I think that was worth it.
All right, welcome. I'm just bringing parties in. I just brought in Tyler English. I'm also bringing in somebody listed as Blake's iPhone. I'm guessing that is Blake English. We are on the record now in the matter of Tyler English versus Blake English. This is file 25-20108CH. Ms. Mott, you can start with your appearance, please.
Thank you, Your Honor. Catherine Mott on behalf of Tyler English. And if I may, I believe that Blake's mom was going to join. Her name is Helen Jessup.
She is in the waiting room. I will bring her in. I don't have any objection to Ms. Jessup being here in the hearing. Blake, if you could unmute yourself and state your name for the record, please.
Hi, I'm Blake English, and
Welcome, Mr. English.
thank you. But I was
Mr.
going to
English, if
say,
you,
oh, you're good. Sorry.
so Mr. English, could you please take your hat off? This is a court proceeding.
Oh,
I recognize
yes,
it's the winter time, but we are in a court proceeding. And Ms. Jessup, I see that you're here. Are you here and just as a mother to view the proceedings on behalf of Blake?
or she was going to speak for me because I don't really understand everything, and she has all the information.
Well, that's not appropriate. I'll explain why. But Ms. Jessup, I need you to first unmute yourself and state your name for the record.
My name is Helen Jessup.
Ms. Jessup, it appears that you have a hat on as well. Are you wearing that for any medical purpose?
No, I don't have a hat. It's a headband to hold my hair back for work.
Fair enough. So that I view as different. Ms. Jessup, the indication that Blake English was trying to suggest to me is that you wanted to appear here today to speak on his behalf. Is that accurate?
Correct.
That's not permissible, and it's not out of any type of disrespect or discourtesy to you, but let me explain why. Mr. English is a party to a case, and under Michigan law, parties to a case can either represent themselves or they can be represented by counsel. You are not an attorney, are you, Ms. Jessup?
I am not.
Allowing you to speak on behalf of Blake English would be akin to, it would be equal to allowing you to represent his interests. And that would be allowing or encouraging, even in this case, the unauthorized practice of law. I cannot and will not permit that. I have every reason to understand why you as the mother would want to weigh in and help Blake. And I understand based upon what Blake is saying, that he wants you to help because he doesn't understand these things as well as perhaps you do. With your experience and your knowledge, you probably have a better understanding than he does. I accept all of that background. Nonetheless, you're not permitted to act as a party or as a representative of a party in a civil case. So while I thank you for being here, Ms. Jessup, other than being able to be here to listen, you're not going to be able to advocate on his behalf or offer suggestions. He's going to have to provide his information on his own. And if he doesn't, I will not consider it. Do you have any questions before we move to the next step, Ms. Jessup?
I don't have a question, but I did want to make a statement that I did reach out to an attorney today. I have sent everything over to him. He's taken a look at it by tomorrow so that someone can help Blake in this matter.
Ms. Jessup, that's fine that you've reached out to an attorney, but I would note that the timeliness or lack thereof of such action is important to the court. You probably know this because you've been involved and you were acting as an advocate on behalf of Blake, that this case got filed all the way back in May 30th of 2025. In other words, within 90 days, this case will be a year old. Throughout that entire process, Ms. Mott has been involved. She's been updating me. And through some of the process, Blake has been involved. Through all of the process, Tyler has been involved because he's had an attorney prosecuting his interests. At various times, Blake has not been involved because he's not been present. So the lack of time period is important to the court. And so if you had an attorney that was hired right now who had filed an appearance, I may hear from that attorney, but I'm not going to hear from anyone who's not here. And I don't find any basis, even to the extent you're making an implicit request to adjourn, I don't find any basis to do so at this point. I would also note that part of the issue here today, and I'm guessing you're aware of this, is that all the way back in October of 2025, Blake, Catherine Mott, the attorney for Tyler, and Tyler all sat down at a mediation and came up with, at least according to Ms. Mott's motion, a full and fair agreement. That agreement, in other words, has been in place for now at least 4 or 5 months. And so if you were asking me immediately after that agreement was reached to hire an attorney or have time to hire an attorney, or more specifically, Blake was making that request.
Judge Hunter is notorious for literally just shutting the shit down. He doesn't take any crap. He follows the rules and he expects everyone else to just do the same.
I might be responsive to it. But when a party, Blake, waits without doing anything for that long, that type of action weighs against any type of discretion that I could exercise. So I understand your statement, Ms. Jessup, and I'm not going to have a back and forth. I'm not interested in hearing anything further. And again, for the reasons I've already stated, you are not permitted to advocate on behalf of Blake. That's not how the process works under Michigan law. Ms. Mott, we are here on your motion to enforce settlement agreement. I've had a chance to read that motion. I have not received any response to the motion. Blake, did you file any response to the motion to enforce the settlement agreement?
I didn't file anything.
Ms. Mott, outside of the written motion to enforce the settlement agreement that you filed, did you have additional brief oral argument that you wanted to offer in support of it?
No, Your Honor, I'll rely on my pleadings, please.
Mr. English, Blake, because you're here, did you have any brief oral argument that you wanted to offer of in response to the motion to enforce the settlement agreement?
Like I said, I don't really understand anything, and there's really nothing for me to say. I don't really have any information. I don't really understand all of this, but
the court makes the following findings then, Mr. English. I've been presented now with your statements and with Ms. Jessup's statements that you don't understand what's going on. However, those claims are really ultimately unavailing to me, and they're unavailing because I have never during the entire pendency of this case been presented any information which I found credible to believe that you are not of sound mind, that you don't have the legal ability to understand what's happening, or that you otherwise don't have the conscientious ability to hire an attorney at any time if you thought you needed answers to questions. In other words, claiming that you don't understand is fine. You've made that claim, but I don't view this as any bona fide claim that you don't have an ability to understand, or that your mental capacity is so low that you cannot contract. If I heard that type of a response, I might give it serious thought, but I've not heard that at all.
well,
What I
we
have
want
heard is a written motion, and I'm not hearing any additional oral argument, Mr. English. The
We
time
wanna
has
buy
come
out the
and it has
land.
passed for you to be able to file a response. And so, Mr. English, I recognize that if I gave you the authority to respond, you may want to continue responding, but I'm not giving that option. The court is exercising its discretion under 2.119E3 to instead dispense with and now altogether limit oral argument. I gave you an opportunity to be heard. You told me you didn't have anything to say. Ms. Mott, an attorney on behalf of the plaintiff, has filed a motion, and her motion is detailed and it's thorough. It goes through the background of this case, and it explains that all the way back, again, at a time of a mediation in October 3rd of 2025, the parties reached an agreement, and that agreement was reduced to writing. It was attached to the motion. And upon several other terms and conditions, the requirements under that mediation agreement, a contract entered between two consenting adults and an attorney on behalf of one of those consenting adults, indicating that the parties agree that Blake English, the defendant, would pay to Tyler English, the plaintiff, 50% of the appraised value of the property issue, contingent upon the appraised value being $150,000 or higher. The next paragraph says that Blake English commits to initiating the loan process within 10 business days from the signing of this agreement. That agreement, again, was signed on October 3rd of 2025. Next, it indicates in the next paragraph that within 10 days after that, after there's an appraisal and then a second appraisal if one is obtained, the parties shall cooperate in listing the property for sale with Kurt Jacobs of Alpine Realty. Parties agree that the list price for the home shall be a minimum of $162,500. And then ultimately, when sold, the proceeds will be distributed equally, accounting for real estate fees and closing costs. So there is clear and unambiguous terms within that mediation agreement. Ms. Mott has now filed a motion to enforce the settlement agreement, and the court rules allow me to force and require that a party files a written brief and motion in support of an issue that presents an issue of law, and to file any response. You didn't file any response. You have not convinced me, Mr. English, that there's any basis to set aside what appears to me clear and unambiguous mediation agreement, and otherwise any reason why I should not enforce the settlement agreement. And so I grant the request by the plaintiff to enforce that settlement agreement. I make the specific finding that it appears to me the agreement is clear and it's unambiguous and it has not been complied with. The parties are required to proceed under the terms of the mediation settlement agreement, and they must cooperate in listing the property for sale. Ms. Mott, under what time period are you asking, and what specificity would you ask in the order confirming or enforcing the settlement agreement?
I will prepare the order and submit it under the 7-day rule. And as soon as we get the order, I will reach out to Kurt Jacobs. I've been in touch with him.
No, I didn't clarify, and I wasn't clear
sorry.
enough. Were you asking for a specific time period? Your request under your wherefore paragraph asks that I should order that the parties proceed under the terms of the mediation agreement and then cooperating listing the property for sale. Do you think I should just issue an order that the property shall be listed for sale through that realtor, through the assistance of you, or do you have some other suggestion on how to accommodate the terms of the settlement agreement?
I think just in order to move on to this next step of listing it for sale would be sufficient.
And then you asked to also have detail in that order confirming or enforcing the settlement agreement, any additional information, or are you confident that both you, Mr. English, Blake English, Tyler English, and the realtor all know the listing terms under the mediation agreement?
I believe that the settlement agreement lists the terms pretty specifically with the list price and the acceptance procedure. And then also with Mr. English, Blake English's responsibility to keep and maintain the home and make it presentable for the listings. So
more specifically though, do you think the realtor is going to have that information, or can you pass that on to the realtor?
I will take control of that.
The court grants the relief that you've asked for. When you prepare an order that conforms with my ruling and submit it under the 7-day rule, what that means, Mr. English, Blake, is that if after you receive that order, you think that a part of that order is incorrect or that it incorrectly states this court's order today, you have an opportunity to file a written objection. If you file a written objection, the court rule requires that you propose an alternative order, what you're asking me to actually order. But to be clear, an objection to the 7-day order is not your opportunity to object to the fact of the order or with what I ruled today. More specifically, it's if you think Ms. Mott has wrongly stated the court's conclusions, that's a proper basis for an objection under a 7-day ruling. If I receive a proper objection, I'll set a hearing. That's what the court rule requires. If I don't, I'll sign the order when it's submitted to me. And then the requirement is to follow through with that order and get it completed, everything that's envisioned in the settlement agreement. Ms. Mott, is there anything else that you need to be heard on today?
No, thank you, Your Honor.
Blake, I'm going to hit the button asking you to unmute. If you have a question regarding the court's order, I'll allow you to ask it and I'll attempt to clarify my answers. Do you have a question?
I just want to say I don't really agree with anything, and I wanted to buy their half out, but they just, I don't know, they couldn't agree with anything. But we tried. We wanted to buy them out, but there's
Mr.
not.
English, the purpose of this questioning was just that. I was allowing you to ask a question if you had any. You not agreeing with the process misstates the history of the case. Your agreement itself is the mediation agreement. You are bound by those terms, but as of yet have not followed through with those terms. So that's the order of the court. I'm enforcing the settlement agreement. Anything further that you have questions regarding, you can cover with an attorney that you plan on hiring if you plan on hiring them. The court is in recess today. I thank everyone for being here.
Thank you.
Okay, welcome everyone. The court is on the record in the matter of the petition of the Otsego County Treasurer for the foreclosure of certain parcels of property due to unpaid 2023 and prior year's taxes, interest, penalties, and fees. Collectively, this is altogether file 2025-20074-CZ. Mr. Middleton, if you could start with your appearance, please.
Good afternoon, Your Honor. Lucas Middleton, appearing on behalf of the Otsego County Treasurer.
All right, thank you. And Ms. Wright, I see you there on the Zoom screen. You are the Otsego County Treasurer, correct? Ms. Wright, if you could unmute yourself and state your name for the record, please.
All right, took me a second. Paula Wright, Otsego County Treasurer.
All right, thank you. And then I have various other individuals. I decided in my discretion to let everyone in. I noted that originally this matter was set to be heard in person. However, there's also been some confusion, obviously, because a lot of everybody is joining via Zoom and not in person. I'm in the Otsego County Circuit Courtroom right now. We have court officers here. So if anybody wants to appear in person, they certainly can, but having you appear via Zoom is also acceptable. I'm also just going to let in anybody who wants to be here for this hearing. This is a matter of public significance. And so, Mr. Middleton, I'm in receipt of your amended petition for foreclosure. And I note that I had a chance to review your petition, your initial petition. And my understanding is typically your office will file an amended petition. And the differences primarily are that the amended petition, if there was one filed, would have only removed those parcels of property, either where there was an agreement reached with the Otsego County Treasurer's Office, payments were made, or there was some other reason to remove the properties from the roll. Is that accurate?
That is accurate, Your Honor, though I would wish to clarify the document which I sent you along with the proofs was not an amended petition. It was simply a copy of the original petition that was filed, so they would be consistent. Your staff had just requested that I send hard copies to your office directly in Grayling so that you were able to have those.
All right. Well, I appreciate that clarification. And just to be clear, I handle these foreclosure matters in 3 different counties. I'm a circuit judge in 3 different counties. And sometimes I do get those amended petitions, and clearly I'm confusing this case with another one. They all tend to happen around the same week in the same month during the same year. In any event, my typical way that I proceed is first I have questions for you, Mr. Middleton, as an officer of the court and the attorney for the petitioner. I ordinarily then put Ms. Wright under oath and allow you to ask questions of her regarding the county's compliance with MCL 211.78K. And then if there was any other written objections that were filed in line with the statutory provision, I would hear those. If anybody that's here wanted to make some oral statement, I probably will allow that as long as time allows. And I say as long as time allows, I have nothing set on my docket until 3 o'clock. And so we have about a half an hour to go through those things. So within that time period, if there are some oral statements that want to be made, I likely will entertain them. Although I would remind everyone here that the statute ultimately is what controls. And that statute is the statute upon which the petition was based, MCL, Michigan Compiled Law 211.78K. Specifically, that statute requires that while a party or a person that claims interest in a parcel of property that's subject to the petition for foreclosure has the ability to contest any reason why the foreclosure is being requested, the requirement under subsection 3 is that they shall, and shall is a mandatory word, file written objections with the clerk of the circuit court and serve those objections on the foreclosing government unit before the date of the hearing. I've had a chance to go through the circuit court file, and I did not see, and I'll go through it again today as I'm talking, I did not see that there was any written objections. I see that there's a formal notice. There's a motion of objection, and so I'm glad I looked again, because since I've looked, 2 different things have been included. There's the affidavit of service of notice of the show cause, and that was sent by Mr. Middleton's office, I believe, but we'll hear some clarification. And then there's 2 different documents. One is by an Anthony Spencer, and I'm trying to see if I have an Anthony Spencer present. Do I have Anthony Spencer present here in my hearing room?
He's on Zoom, Your Honor.
Mr. Spencer, are you present with us?
Yes, sir.
All right, and are you Anthony Spencer?
Yes, sir.
So I see that you filed on yesterday's date, February 2nd, a motion of objection, property forfeiture. I'll let you be heard on that issue. You did comply with the statute in filing that written objection. And then I saw that there's a Randy J. Chafee also had a written document. Is Mr. Chafee present?
Present.
All right, so Mr. Chafee, and thank you. You reminded me already when I brought you in. Mr. Chafee is under Mr. Holly's name. Mr. Chafee, I'll let you be heard. I've not yet had a chance to read your formal notice of appearance by Randy Chafee, but we'll cover that. You also filed that in writing yesterday's date before the hearing. In my view, that's confined. That is at least in conformity with the statute in terms of the objection. So let's start with Mr. Middleton, what you wanted to offer in support of your motion and or your request for the entry of a judgment today. Then I'll swear in Mr. Wright, then I'll hear the objections.
Thank you, Your Honor. Your Honor has done a good job of laying the framework for what we're here to do today. Primarily, Your Honor, I would wish to take some testimony from Ms. Wright in support of the efforts that she has undertaken since the petition for foreclosure was filed last year, including the efforts that she has undertaken to provide notice by mail, notice by posting and personal visit to each property, as well as notice by publication. And so if Your Honor would allow Ms. Wright to be sworn in, I would ask to take that testimony now, unless Your Honor has additional questions.
I do not at this juncture. I may come back to that point. Ms. Wright, if you could raise your hand to be sworn, please. Do you solemnly swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. Your witness, Mr. Middleton.
Thank you, Your Honor. Ms. Wright, could you please state your full name for the record?
Paula Wright,
And Ms. Wright, could you please tell us your job title?
Otsego County Treasurer.
And as part of your job duties, did you prepare a list of properties that was attached to the petition for foreclosure that was filed in this case last year?
Yes.
And what did that list contain?
Includes the parcel ID, the legal descriptions, the amount of the taxes and interest and fees that are due.
And are those the parcels that have been forfeited to your office?
Yes.
And Ms. Wright, as part of your job duties, did you also prepare a list of properties that will be attached to a judgment of foreclosure that will be presented to the court today?
Yes.
And when was that list prepared?
This morning.
And is the list that was prepared for today the same as the list that was attached to the original petition?
No.
And could you please explain the difference between the list on the petition and the list that will be presented today?
The list today has numerous ones removed that were either paid, some have been already marked withheld, some were in bankruptcy or numerous other reasons.
So the list that will be presented to the court today contains fewer parcels than the list that was attached to the original petition. Is that correct?
Correct.
Ms. Wright, for all the properties on the list that will be presented today, was a title search performed to identify all the parties entitled to notice?
Yes.
And who performed that title search?
Title Chuck, LLC.
And for each parcel on the list that will be presented today, did an authorized agent of your office make a visit to that parcel to determine whether or not it was occupied?
Yes.
And if a property was occupied, did the agent attempt to notify the occupant of the show cause hearing and the foreclosure hearing today?
Yes.
And did you receive proof from this agent or agents that each property that is subject to foreclosure today was in fact visited?
Yes.
And was that proof filed with the court prior to today's hearing?
Yes, it was.
Ms. Wright, did you hold a show cause hearing as required by MCL 211.78J?
Yes, in January.
Ms. Wright, did an authorized agent of your office also send a notice of the show cause hearing and of today's foreclosure hearing by certified mail, return receipt requested to all those parties that you identified who were entitled to that notice?
Yes.
And was a proof of this mailing prepared by the agent?
Yes.
And was a copy of that proof filed with the court prior to today's hearing?
Yes, it was.
Ms. Wright, was a notice of the show cause hearing and of today's foreclosure hearing published for 2 successive weeks in a newspaper publication?
Yes,
And in what newspaper was that publication made?
the Gaylord Herald Times.
And was a proof of this publication filed with the court prior to today's hearing?
Yes, it was.
Thank you, Ms. Wright. No further questions for Ms. Wright, Your Honor.
So the way I'm going to go through this first is the court may have some additional questions, but given there are 2 parties that filed written objections, I'm going to give each of those parties an opportunity, if you have any questions, to ask them of Ms. Wright. So in no particular order, Mr. Chafee, did you have any questions for Ms. Wright regarding her testimony so far or otherwise?
No.
And then Mr. Spencer, did you have any questions for Ms. Wright regarding her testimony so far or otherwise? I'll give you a moment to get back connected. I think you were on the Moto G Power.
Can you hear me now?
I can, thank you. Did you have any questions for Ms. Wright based on her testimony or based on anything else?
There was something in there. I have to come back to it in a moment, sir.
I don't know what that means. So what, can you explain to me what that means?
The other gentleman was asking her questions, and there was one question there that I didn't quite hear. It kind of like just bleeped on me. I'm not sure the noise wasn't very good on my phone.
Well, I don't have a solution for you in that regard, Mr. Spencer. If you have questions, you're entitled to ask them, but I can't remember line for line every question that Mr. Middleton asked, nor what the answers were by Ms. Wright. So do you have any questions for Ms. Wright?
No.
All right. So then the court would have just a couple of follow-ups. Ms. Wright, have you also, in your capacity as the Otsego County Treasurer, assisted Mr. Middleton's office in the preparation of this proposed judgment of foreclosure?
Yes.
And are you familiar with generally the requirements under MCL 211.78K regarding the foreclosure of properties?
Yes.
In your capacity as Otsego County Treasurer, do you undergo any sort of trainings or updates regarding compliance with those statutory provisions?
I have numerous certifications and I attend multiple trainings throughout the year.
All right. And specifically, are you aware of the fact that under the statute 211.78K, there are several different legal requirements of things that must be in the judgment?
Yes.
And have you reviewed the judgment prior to today's date?
I looked through it this morning and that, yes.
And based upon your understanding of the statutory provisions, do you believe the judgment meets those terms?
Yes, I believe so.
Mr. Middleton, this is a question for you, and on purpose, I'm not putting you under oath. You're not a witness. I understand that. You're an attorney. You're an officer of the court on behalf of the petitioner. But is it accurate for me to understand that you assisted in preparing this judgment of foreclosure?
That is correct, Your Honor. I drafted the judgment, and Ms. Wright generated the list of properties from her delinquent tax software, which is attached as Attachment A.
As an offer of proof and as an officer of the court, can you confirm for me that the judgment of foreclosure, to the best of your knowledge, information, and belief, does contain all those items that are required, specifically under 211.78K, subsection 5, A, B, C, D, E, F, and G?
Yes, Your Honor. I've prepared the form judgment that I utilize in conformance with the statute, and I'm very intentional about ensuring that it is in conformance. I represent a number of counties, and I'm very familiar with the tax foreclosure process, and in particular MCL 211.78 at SEEK.
All right, thank you. So then I'm going to move to each of the parties that had filed the written objection. I'll start with you, Mr. Spencer. Mr. Spencer, you had filed a written objection. Did you wish to offer oral argument in support of that written objection?
Yes, sir.
Go ahead, please.
I had purchased the property in 2022, and when I first got the property, there wasn't a mailbox or anything here. I moved onto the property immediately, but I had to put a mailbox in, change the address, and there must have been something going on with the mail because it wasn't getting sent. So when it was a $23 and I think 89-cent error that the clerk treasury had made. They sent me a paper saying I owed X amount of dollars, and I had like 3 or 4 days. If I paid it, there would be no add-ons or no extra fees. So I had called up there, made sure everything was up to snuff, and I was like, well, I didn't receive this one here. Is there another address that my mail could be going to? And I found out it was getting sent down to another county downstate. So that's why I didn't receive it. So I paid it that day, and I put an extra $1 in or something. And about a week later, I got a letter from the Treasury Department saying that the amount and the date that they gave me was an error on their behalf, and that this is the new amount, and you must pay it by this date. Well, when I looked at the date, it was already 2 days past the late day, and it automatically put me into this foreclosure forfeiture over $23 discrepancy.
So what are you asking the court to do by way of your objection then?
Well, I called up there and said, you know, I didn't make this error, this problem. Is there a possibility that I could still pay it, because I just received it in the mail today, and it was postmarked and everything, that it was postmarked there, but it wasn't my error. If I would have paid it the following week when I paid the other $98, I would have added that rate to it, but I wasn't told I had to pay that, and they never sent me that. They said it was the wrong amount that they sent me, and that and I asked, well, why can't you just apply that and I'll just send the extra additional dollars? And they said, well, it's too late now. It's by law, I have to do this. And I said, well, you know, you admitted it was a clerical error. You sent me the letter stating this, you know, and when I got the letter, because I just talked to you last week and I paid it, now I'm 2 days late, and it's only because I just received the original copy. So I didn't know the exact amount that I was supposed to take care of. And my tax
The amount you're supposed to take care of now, Mr. Spencer?
Excuse me?
Do you know the amount that you're supposed to take care of now?
Well, I just sent last week. This is the second time I sent last week, another $98 for last year's taxes. And I checked the box on the tax bracket, and I checked it and see, because I was trying to wait till this court date so I could refute this issue. This is why I've been waiting almost a whole year to refute it, because I don't feel I have to pay $400.
What are you asking the court to do with respect to your property, Mr. Spencer?
Well, I paid the taxes, and they've taken the money that I'm paying for the year that I'm paying, and they're applying it towards the thing that I'm here refuting right now, the clerical error that caused me to be in forfeiture.
What are you asking me to do today?
To take the forfeiture off and let me pay that $23.89 that I could have paid the day that I received the original the paper, but they made the mistake and they admitted it in the paper.
Your claim is that if I don't take the action you're requesting, you will have to pay the difference between what you think is a $22.89 and the total amount of $98 that you've tried to pay on the last couple of days. Is that your contention?
Sir, you have a really loud voice. It just really I'm having a hard time hearing it. It's like,
well, I don't have any way to change my voice. I can try to talk a little bit quieter, but the audio system that you're using is the audio system you're using. My question is your contention that what you should have paid or required to pay is a $22.89 and not the total of $98 because of the claim that there's a clerical error on your behalf?
yeah, the clerical error was on the treasurer's behalf, and I paid $98, and then they sent me another paper saying that I needed to pay an additional $23.98 or something like that, but I couldn't pay it because it was already said that I was late, and it would automatically go into forfeiture because the mail.
Spencer, what I'm trying to understand is the point of contention as it's boiled away. Your contention is some $70, and I'm not trying to make light of it, but $70 between what you think was the original bill and what you're now being forced to pay because you're claiming there was a clerical error. Is that right?
Yeah, no, it was actually like $400 they're trying to get me to pay for the forfeiture fees.
So part of the reason, Mr. Spencer, I'm taking time to examine this in detail is, at least in part, your objection complies with the statute, which is this statute 211.78A says that you, as a person claiming an interest, can object to the foreclosure. You can contest the validity or correctness of it. And
Yes.
the ways that you can do that is if you think that no law authorizes a tax, or that if you think they acted without jurisdiction or didn't impose the tax in question, or that the property was exempt, or that the tax has been paid within the limit allowed by law or payment for redemption. The issue with your objection is your objection was frankly very short and to the point, but I don't still understand the point. You just objected and said there's no due process. You didn't provide any of the information about what you claim to be the discrepancies in payments. For the first time, I've heard the number 23, and then you brought up that it was 98, and now you're saying it's $400 some. The issue for the court is that Mr. Spencer, is that the reason there's a requirement to file an objection in advance of a hearing is it provides me with the opportunity to have the information. It provides Mr. Middleton, the attorney representing the county, to have the opportunity to be prepared to respond to it. So I don't know how I'm going to respond to it. I'm going to find out if Mr. Middleton can respond to it. But the reason there's a specificity requirement in an objection is so that I can be prepared to respond. I'm not prepared to respond when you bring up issues that weren't set forth in your objection itself. That's the reason for the written objection. So Mr. Middleton, on behalf of the Otsego County Clerk's Office, or the foreclosing entity rather, do you have a response to Mr. Spencer's claim of error with respect to a clerical error or due process claim?
Your Honor, I believe I would need some brief input from the treasurer. I think she could more clearly express what his alleged clerical error is and confirm our understanding. And I believe that it is not a material issue that would change the outcome here today, but I would, Your Honor, ask that the treasurer clarify what the precise issue alleged was.
So I'm not going to do that. What I am going to do is hold in abeyance any determination as to Mr. Spencer's property. In other words, ultimately, when I make my findings, I'm going to require more. And what I require is in line with the statutory provision, Mr. Spencer. You have a right to be heard, and I'll let you be heard in full. But what you need to do in order to fully explain your position to the court is do so in writing. You need to tell me what it is that you think is wrong with the process, why you think it's wrong, and then specify. And you're holding up a piece of paper, Mr. Spencer, but I don't have it. If you want me to consider it, you're going to supply it to me before our next hearing. And I'm going to have a hearing as soon as I can possibly get it set. But I'm going to require that you put forth in writing what your objections are, why you're objecting, and what relief you're asking for with specificity. By doing that, you will give Mr. Middleton an opportunity to understand your claims and then be able to respond to them. Once I have your objections and Mr. Middleton's responses, then I'll rule on the merits, but I'm not going to do it in reverse order. It's not fair to me in my estimation because I have no idea what the nature of the objection is, and I'm not going to operate on the fly today. So ultimately, when I sign, if I sign any judgment to foreclosure, it's going to be accepting Mr. Spencer's potential issues until I rule on another day. Mr. Middleton, that means to the extent I grant any foreclosure, I'm ultimately going to require that you prepare an amended proposed order, again, for the reason stated on the record that until I rule further, it's not going to have anything to do with Mr. Spencer's property. Do you understand what I said so far, Mr. Middleton?
Yes, Your Honor.
Mr. Spencer, do you understand what I've said so far? Mr. Spencer, do you understand what the court has said so far?
Yes, yes, sir.
Okay, I wasn't able to hear you. Mr. Chafee, I'm going to ask the same questions of you.
You didn't hear him because he was busy sulking.
Which is, I need to get a generalized understanding of what your objection is. Your objection is also short and to the point, and there is claims of malfeasance, nonfeasance, that you don't understand why you're being contacted, and there's things being dealt with in higher courts. I don't have any involvement, of course, in those higher courts. I don't have any idea what your claim is. So I'll let you briefly articulate them on the record today. But like Mr. Spencer, while you have a right to contest the matters, and while I will hear and determine them on the merits, the reason that I require, and the statute requires, written objections and written responses to objections is so that I can be prepared to rule on the merits today. I don't have that ability yet. At least I don't think I do, but I'll hear from you. So Mr. Chafee, what is the nature of your objection?
My objections have to do with the foreclosure of this is also affecting several other parties that have claims.
Well, those parties, to the extent they had an objection, had the right, had is in the past tense, to file an objection. They were notified of that right, and the statute controls in that regard. So I note that you're trying to object on behalf of other people, but that's not permissible under the statute. Each party who filed a timely objection is going to be heard by me on the merits, and that's you, and that's Mr. Spencer. So in terms of your own objections, did you want to state them today, or would you like an opportunity to further clarify them in writing so that I can be prepared to address them on their merits?
Yes, I'd like to further clarify them.
So again, to clarify what I need, Mr. Chafee, and what the law requires that Mr. Middleton is entitled to, is reasons what you're asking for, why you're asking for it, and then specifically what it is you're requesting the court to do and why. Once I have that objection, your clarification, your indications as to why you're objecting, I'll provide Mr. Middleton a reasonable opportunity to respond in writing. Then I'll have the benefit of your objection, his response, and when we have the hearing in the future, I'll be prepared to rule on the merits. Mr. Middleton, do you think I should set a specific time period for those conforming objections to be refiled?
Yes, Your Honor, I think that would likely help keep things on track. I would note that I'm very familiar with Mr. Chafee and with his objections, as he's appeared, I believe, at each of the last 5 or 6 annual foreclosure matters. Again, I won't belabor the court because I think Your Honor has expressed that you want to hear about this later, but I would simply note for the court now that I don't believe Mr. Chafee has standing to raise objections at all, as he does not own the property. It's been transferred numerous times since he was the fee owner. It's currently owned by an entity called Running Caterpillar American Church 5.
That could make things difficult. I mean, it's one thing when the property is foreclosed upon and just taken over by the county or whatever, but when it's been sold off more than once, that's a tangled web of paperwork that I don't think the court's going to want to get involved in.
08 C1A Inc. And not by Mr. Chafee.
Well, and that's fine. If that happens to be my legal conclusion, I'll make sure and state that for the record as cleanly and clearly as I can. I understand that to be your position right now, Mr. Middleton. Well, here's what I'm going to require is within the next 14 days following today. So today is the 3rd day of February. By February 17th of 2026, no later than the close of business at the clerk's office, Mr. Chafee and Mr. Spencer, you are required to file in writing detailing what your objections are, what you're asking me to do, and the legal basis upon what you're asking me to do. And you're to file a copy both with the clerk's office, supply a copy, which is called a judge's copy, to my staff, and I can give you the address that you can send that. An email address is fine, an email copy to my staff, and a judge's copy is required. That's because I'm in 3 different counties. And then you'll have to arrange and serve Mr. Middleton with a copy of that as well. Mr. Middleton, within 7 days after those are served, I expect you to file a written response to each of those objections. And then once I have those, I'll have my staff notice up a hearing. Mr. Middleton, if you have 7 days from the time that those are filed, does that give you enough time to respond in writing?
I can make that work if that's the timeline that Your Honor is comfortable with.
I don't have a particular comfort level. What I guess I just want to get is some brief input from the parties. Let me start with you, Mr. Spencer. If I give you 14 days to file your written objection and provide all the detail that you need, is that enough time for you?
I think so. I have all the letters. I have a whole file of all my taxes that I received in the paperwork. I asked to come into court today physically to hand those in, but I was told I was only allowed to do the Zoom. So,
well, I don't know who would have told you that. My docket was noted by in person. The courtroom's open right now. I have court deputies here so that we can have a full in-court proceeding. And I'll note that at our later hearing, I don't have any objection to people appearing in person. So if you want to appear in person, make sure and note that, let my clerk know that, and we'll have you here in person. That's not a problem.
Okay. Yeah, no, I did that yesterday. They said that it's just Zoom ever since COVID. So
that would be Your Honor.
Again, I don't know who told you that, but I have it set as an in-person hearing. If somebody said that or assumed that, that's fine. People get things all the wrong, but straight from the horse's mouth, so to speak, this will be an in-person proceeding at our next hearing. I think that's the most conducive to having a clear and clean record being made. Mr. Middleton, do you have any opposition to appearing in person at our next hearing?
I don't, if Your Honor would prefer to have me in person. And I apologize that, and I believe when I spoke to your staff and got the hearing date for this hearing last year, that they expressed that it would be a Zoom hearing and I should notice it as such. So there was clearly some crossed wires in that regard. So I apologize for that today, Your Honor.
No, and I appreciate that. And if the cross wires were on my end, that's fine too. And that very well could have been, because sometimes I have an assumption about how things are going to proceed and I don't clearly articulate those to my staff. Mr. Chafee, do you have any objection to the 14-day time period for the filing of any objection and detail providing the background of that objection?
No objection.
So, Mr. Middleton, if I give those parties 14 days, are you asking for 14 days or do you think the 7 is enough?
14, I think, would be helpful, Your Honor, is particularly depending on, I don't know when I'll ultimately get those in the mail. And we have some pro se claimants here. So 14 days would be helpful.
Then the court will allow that 14-day time period by the petitioner. And then ultimately I'll set a follow-up hearing in person to resolve these two particular written objections, the one by Mr. Chafee and the one by Mr. Spencer. And I'll set aside approximately a half hour to 45 minutes for that time period in case we need some brief questioning by me or questioning by the various parties or litigants. Mr. Middleton, well, let me state it this way. It is 3 o'clock. I do have other matters coming up. However, these are important matters. Is anyone else here on a particular piece of property that thinks the court should hear input from you?
Yes, Your Honor. Jennifer Schaefer here on behalf of Northern Way Asatru Assembly. The authorized member of that is Jason Ashton, who's also present on Zoom. I appreciate the court's allowing us some time here. I'm a bit confused because we did actually file a response to the show cause as well as an objection to the foreclosure. It was actually titled that. It was personally hand-delivered by Mr. Ashton to Ms. Wright as the treasurer. It was discussed with her and also, I believe, delivered to the clerk's office, discussed with them. And so I'm not sure. And I put my appearance in just a little bit earlier today. I apologize, the court was not aware of that. So I have taken a look at what was filed, and I actually I think it does in fact explicitly state the reason for the objection to the foreclosure, which is and has been for the past, I believe, 5 years, a religious exemption that has been denied by the Corwith Township assessor.
I don't see any of that in the court file, and I'm looking through it now, Ms. Schaefer. I certainly don't have a copy of anything, and Ms. Schaefer, as you know, under the court rules, to the extent you have filed anything in response to an ongoing petition, motion, or otherwise, the court rules explicitly require a judge's copy being sent to me. If I had it from you, I would have considered it prior to the hearing. So you can send it also to my staff. It's required. It's not just expected, it's required. I don't have it. I'm looking through the court file, and I don't see that any objection has been filed by you. If it's in the court file, I'll stand corrected. The court file is not that thick, but I'm going through it now and I don't see any objection. Mr. Middleton, did you have any objection from Ms. Schaefer?
Not from Ms. Schaefer. Again, I believe she's just appeared today as attorney for the assembly. I did receive a copy of an objection that was served on the treasurer. I don't know whether it was filed with the clerk or not, though, Your Honor.
Your Honor, it's my understanding that it was actually the treasurer, Ms. Wright, and please correct me if I'm wrong on this, I'm getting this information from my client, that there was actually a representation that it would be delivered to Your Honor, so you would have a copy as well as the clerk. So if there's been any, again, something missed in that regard, my understanding from my client was that that was in fact done to deliver to the treasurer, to deliver to copy to Your Honor, and also to the clerk. But of course, I'll stand corrected if Ms. Wright has something different in her recollection.
It's not the treasurer's obligation.
I'm not going to hear any type of response from Ms. Wright. And the reason I'm not is because the requirement from any party who has an interest in land is to file objections with the clerk. It's not to hand them to other parties, to have other parties file them for them. And so even to the extent I heard a suggestion that a clerk volunteered or a deputy volunteered or court staff volunteered. The question is either under the statute, the objection has been timely filed with the clerk's office, in which case I will rule on the merits, or the objection has not been timely filed and I'm not going to hear it. So while I understand that you're trying to advocate on behalf of your client, again, the problem, Ms. Schaefer, is that all of this could have been done well in advance, the literal eve of this hearing. And if it hadn't been done in advance, if the court rules had been complied with and I got copies of things as I'm required to have, I would not only be ready to rule, but I would rule on the merits and rule in your favor if I was convinced that there was any merit to your objections. But none of that has happened here. So I note that you have a right to be heard. I let you be heard. And now I'm going to move on and make further findings. Is anyone else here other than Mr. Ashton, who is represented by Mr. Schaefer, that's here and wanted to be heard on some specific item of real property?
Yes, I would.
Yes, Your Honor. On
State your name,
behalf,
please.
Are you able to hear?
go ahead.
State your name, please, Mr. Leibold.
Yes, my name is John Leibold. I am the trustee of the Robert Leibold Trust for Lot 31 in Mishaway. There are some back taxes due. We think we have the situation under control. My brother Kurt is living at that property. He's been living there since 2011 when my father passed away. Kurt is a vet, double amputee, had some real health issues of several years back and got behind in his taxes. So we've been working with Paula and the assessor's office and have got him. We had him caught up, but he's had more health issues and have kind of set him back. Where we stand right now is the assessor's office should have in hand a recommendation that was made by the Otsego Treasurer's Office on how we could change the tax rate so that he could take advantage of the PRE or homestead, as I understand it, because he's been paying taxes there for a while, but he's on a very limited income and cannot afford to pay, has not been able to afford to pay the taxes. So I had been helping him out for a while. We got caught up, and then in the last couple of years, he's fallen behind. So he is behind in the taxes. What we have decided to do is to retitle the property. There's a quitclaim deed that's been issued that would take the property out of the trust and put it in his name so that he could be eligible for the homestead or PRE exemption.
You have got him caught up several times. Either he should have been cognizant of the need to pay the taxes, or you should have been cognizant of the fact that he was continuing to be delinquent.
And then we would readjust the taxes and then get caught up. And I think with that solution that I think Paula's office has suggested and recommended, that we're going to be able to keep them in the house. Otherwise, we're going to have to find something else. So I think we have a solution in place, and that's kind of where we're at right now. But we are behind in taxes for 2023, 2024. And 2025.
Thank you, Mr. Leibold. So the court notes that I have numerous other individuals in my hearing room right now. I would also note that I have 4 other parties who are waiting patiently for hearings at which have been scheduled for sometimes more than months. And those were set to start at 3 o'clock. It's already 3:06. So the court notes that I'm not going to hear anything from any other party, and here is why. There are processes in every court proceeding. And while I'm generally of the view that if I have time to manage and hear objections, even if they're on the fly, I should do so, I'm also at the point where I don't have that ability any longer. I have other hearings that have to take place, and those have also had parties who are interested in matters and who have time constraints as well. The statutory provisions at issue are clear and they're unambiguous. Parties who have an interest in property have an ability to fight that process of foreclosure if they believe that the foreclosure is contrary to law or any of the circumstances otherwise listed in the statute. But the process also requires filing objections in advance of a hearing date. This hearing date has been set well in advance. Typically, I receive requests from the county of Otsego, Crawford, and Kalkaska, those 3 counties where I'm a circuit court judge, approximately a year in advance to set these hearings. I also set show cause in advance before. And so the time period for the filing of objections isn't something that just was artificially created by the court in the last couple of minutes. It's something that's been within the statute of 211.78K for a long time, and it's a legal requirement. So as I've already stated, but as I'll state again, with respect to Mr. Spencer and Mr. Chafee, there was written objections that were filed, and I'm going to issue a ruling on the merits regarding those objections. I do require that within 14 days of today's date, no later than 2/17 of 2026, that those objections and all the detail that's necessary for me to resolve them is filed in writing with the court, a copy to my staff, and the clerk's office can provide that address, and a copy to Mr. Middleton. Mr. Middleton, you have 14 days after that date to file your written response. I'm going to set an in-person hearing relative to those two matters, but relative to those two matters alone, any other request is going to be by a different application, and one of those applications could be a motion for reconsideration. And if that's a motion for reconsideration that's properly filed, then perhaps I'll address it. If it's not properly filed, I won't properly address it. The other option is an appeal. But outside of that, the court makes the following legal findings. First, I credit the testimony of Paula Wright. She told me that she's the Otsego County Treasurer. She's been in that capacity. She indicated that the list of properties attached to the petition for foreclosure included the listing by parcel ID, legal description, address, and it had a compilation of taxes, interest, fees due, forfeited, that have been, and that all of those properties have been so far forfeited to the office. The list was prepared this morning for the judgment and the listing in the judgment. And the only thing that I'll exclude from the judgment as of this moment is anything with respect to Mr. Spencer's property or Mr. Chafee's property for the reasons I've already indicated. All other than that, the court again credits the testimony of Ms. Wright. She indicated, and I credit her testimony, that title searches were done. That's a requirement of the statute under 211.78K. She also indicated the name, title check, LLC of the company who did it. She also indicated that certified agents of her office had visited each and every property. If occupied, there was attempts to notify of both the show cause proceeding and this foreclosure hearing. And there was proof of service filed with the court, and that's in the court file for each one of those visits for each one of the listed properties on the roll. There was also a show cause hearing held pursuant to statute as is required. There was a notice sent to each party by certified mail. There's also been proof of service and filed with the court. There's been publication in the Gaylord Herald Times. All of those things are directly in line with the statutory requirements. I've also had the chance to go through not only the judgment myself, but I also asked for an offer of proof by Mr. Middleton, an officer of the court, who certified that under his understanding, the judgment that's been supplied has all of the language that's required under 211.78K. The court finds that all of the due process concerns have been followed and all of the requirements under the statute have been followed. The court further points the parties, anybody that's interested in this matter, to the final part of the order. This is on my page 5 of the order, and that is under subsection L. Ms. Wright, as the Otsego County Treasurer, you are entitled to continue to remove parcels from the list, even when they're included in this attachment A for redemption, exemption, or otherwise in accordance with the law on or before March 31st, 2026. And what that means specifically, and Ms. Wright, I'm fully aware that you know what I mean in this regard, is if you reach agreements with property owners individually to remove them from the foreclosure process because they have a written agreement to get payments done, or otherwise under different legal strategies or allowances under statute, court rule, or a certified case law, I allow you to do that infinitum into the future. Are you aware of that authority that's vested under this order to you, Ms. Wright?
Yes, sir.
So in other words, if you reach those agreements with any individual property owner, the court finds that to be appropriate, and you can issue that in writing as an amendment to this judgment. And as long as it's an amendment that benefits property owners, the court will never take an exception to any of that process. With that being said, though, I find it otherwise appropriate to sign the judgment of foreclosure on today's date. Mr. Middleton, what I need you to do is just repeat the judgment of foreclosure itself, withholding those two different properties that were objected to or objected by, and that would be Mr. Spencer's and Mr. Chafee's. Again, I understand your argument already with regard to Mr. Chafee that you claim he doesn't have an interest in property, but at least withhold those items that you know he's talking about until I make a further order. When I have that hearing at my next available date for an evidentiary hearing in person, I will make my order on the record on the merits for those matters. Mr. Middleton, do you understand the nature of the order I need from you?
I do, Your Honor.
And because you're the prevailing party, even though I'm adding some conditions, I'm also going to tell you to prepare an order for my benefit, which is an order saying 14 days from today that Mr. Chafee and Mr. Spencer must file those written objections detailing what they have, that you have 14 days thereafter, and that the court is going to set out a evidentiary hearing, at least an argument or status conference or hearing rather, regarding the follow-up on these objections, and that will be an in-person proceeding. Can you also prepare an order that contains those 3 items?
I can, Your Honor. Just to clarify, are you asking me to prepare a separate order, or could I just include those specifics in the judgment of foreclosure with the parcels that are withheld?
It's a fair question, but I think, I'm just trying to operate off the fly, I think it's going to be cleaner to have a separate judgment. One is a judgment of foreclosure. Second is that as to the objections of Spencer and Chafee, they have to file them within 14 days. You have 14 days thereafter to respond, and the court will set out a new hearing on those particular objections as an in-person hearing. So can you prepare that as a separate?
That's not a problem. And Your Honor, with regard to the foreclosure judgment, would you like to just strike the 2 properties from the list, and then we could use the existing copy? I can tell you where they are quickly.
I will do that. That makes more sense to me than having you recreate the entire wheel.
Yes, so Mr. Spencer's parcel is on the attachment A has a page numbers at the upper right-hand corner. It's page 3 of 14, and it is the last property on the page.
All right, I see it, Anthony Michael Spencer. What I'm doing is placing an X there, and then I'm putting my initial CGH, that it's clear that I struck it, and that will address it later. And then the other one?
The Chafee property is on page 5 of 14. It is the second parcel listed.
I see that. I've also aligned it out. I should have done an X again. I actually did like a swirly line, but again, I'm putting my initials right next to it, and the court otherwise finds the judgment of its accordance with the statute, and I'm signing it on today's date. Mr. Middleton, thank you for preparing that additional follow-up order. As to anyone else that's here, I appreciate that you're interested in this matter. For all of the reasons I've stated, however, the court has to move on and conclude other business today. The court is in recess.
Thank you, Your Honor.
CBH. What do you think his middle name is? I vote for Bartholomew.
All right, welcome. We are on the record in the matter of Elmer Screen and Dozer Inc. versus Travis Glazier. This is file 24-19868CK. Ms. Powell, if you could start with your appearance, please.
Good afternoon, Your Honor. Danica Powell on behalf of plaintiff.
Thank you. And Mr. Glazier, are you with us? Mr. Glazier's in my hearing room, just getting connected. It's like.
Oops.
Mr. Glazier, I'm hitting a button asking you to start your video. It sounded like you were connected via audio. State your name for the record, please.
Travis Gerald Glazier.
Thank you and welcome, Mr. Glazier. As you know, we had set what's called a debtor's examination in the past. You did not appear at that debtor's examination, and so in my discretion, I chose to issue a bench warrant. That was also at the request of the party for the plaintiff. Then you were arrested on that bench warrant. My counterpart, the other circuit judge in the county, issued an order releasing you and setting this for a further hearing. Are you aware of that background?
Yes, Your Honor.
So the entire purpose of the bench warrant and then ultimately the release and setting this for a new hearing is to allow you and allow Ms. Powell on behalf of Elmer Screen and Dozer Inc. to conduct a debtor's examination where you have to provide under oath answers to questions regarding your assets for purposes of allowing a judgment to be collected. Are you aware of that?
Yes, Your Honor.
So ordinarily what that means is I will put you under oath and then I'll have you talk to the plaintiff's counsel. And if they're satisfied, then we'll be done. And if you're satisfied, then we'll be done. If there's additional issues that need to be taken up, I generally require those to be filed additionally and I'll rule on the merits. For example, if plaintiff's attorney doesn't believe you're supplying truthful answers, we may have to have another hearing in the future. Do you have any questions about that?
No, Your Honor.
Did you bring to the hearing today and are you able to provide information to Ms. Powell regarding all of those things they requested?
Unfortunately, I don't have them with me today. So when this first started, I was in the process of filing bankruptcy, and I have since filed bankruptcy, and I'm working on all that. So the attorney that I hired told me that part of this court hearing should probably actually should be held off now that I have filed for bankruptcy.
Well, that
However,
might
she
be
said,
accurate, Mr. Glazier, if you provide notice to the court of that fact. So if you
okay,
provide this in writing to the court of the fact or the claim that you file an application for bankruptcy protection, ordinarily that has the effect of what's called staying state court proceedings. There are exceptions to that rule, but ordinarily that's a true statement. But it is not something that happens magically because I don't have any awareness of that. And it looked like to me, Ms. Powell didn't have any awareness of that. Ms. Powell, are you aware of any bankruptcy filing?
I'm not, Your Honor, and I did perform a PACER search before logging on today and nothing popped up at this point.
So, Mr. Glazier, what you have to do, if in fact you have filed for bankruptcy, is you have to provide a certification to the court of that fact. If you provide that certification to the court of that fact, then ordinarily, again, the court is required to stay the matter until further order from that federal court. But that's not happened yet. You haven't provided it. The federal court hasn't provided it. No attorney on your behalf has provided it. And so that leaves us back where we started this process, Mr. Glazier. I ordered you to appear here. When you didn't appear here, I issued a bench warrant to secure your presence. Judge Mertz, in his kindness and deference, decided to release you on that bench warrant, and he specifically ordered these words. You are ordered to appear before the court on Tuesday, February 3rd of 2026 at 3 p.m. by Zoom and have all pertinent financial information ready and available. I'm assuming you got a copy of that order since it was the order that released you from the Otsego County Jail, correct?
correct, Your Honor.
And now, after having had a bench warrant issued against you, you appeared to the court again without that financial information, which was directly required under the order?
That's correct, Your Honor.
How do you think a court should react given those circumstances?
I understand your frustration. I made a poor assumption that it would be handled through my attorney, Marissa Waltman out of Gaylord. I shouldn't have made that assumption, so I apologize for that. But
Ms. Powell, are you familiar with an attorney named Larissa Waltman out of Otsego County, Gaylord, Michigan?
I am not, Your Honor.
So there is an attorney named Larissa Waltman. She practices law here in this community in Otsego County. And it's Larissa, Mr. Glazier. Is that the attorney you're referring to?
yeah, yes, Your Honor.
And your certification or suggestion to the court is that you hired her for the purposes of bankruptcy proceeding?
That is correct.
Do you know whether or not she's filed bankruptcy on your behalf?
I can't answer that with certainty that if she has proceeded with the paperwork. I hired her in the middle of December, so probably a week or two after my arrest and release, I obtained her as legal counsel.
Ms. Powell, given the things that Mr. Glazier said on the record so far, the things that I've reiterated, how do you suggest the court should proceed today?
Well, I know how Mr. Glazier should have proceeded. Immediately upon getting released from jail, he should have been collecting every single one of those documents and scanning it as a PDF.
Well, Your Honor, if Mr. Glazier is in fact represented, I have a moderate discomfort in proceeding without his counsel present, though I know she is not appearing in this case. It's strictly for bankruptcy purposes. I would indicate to the court on December 2nd, pursuant to a conversation I had with your clerk's office, I did send to Mr. Glazier a letter reiterating the documents we were looking for. So, Your Honor, at this point, even if we were able to conduct the debtor's exam, I think we're probably going to need at least a control date after that for documents in the event that bankruptcy is not filed. I would also indicate that the default judgment is against Mr. Glazier and his entity. There has been no indication whether the entity is filing for bankruptcy or if it's just Mr. Glazier individually.
Well, and that might be an important legal distinction, but perhaps not, at least according to the representations you made, I think, when you got the judgment in this case. Ultimately, it was your belief that Mr. Glazier was the head of TG Concrete and Restoration, and you'd have to go through him for purpose of document collection and collecting a judgment, either individually or through the company, right?
Yeah, yes, Your Honor. I do believe if individually and not in a corporate setting, I believe we could proceed against his entity solely with understanding that we are not attempting to obtain information regarding individual assets, but solely bank accounts, assets, vehicles, whatever it might be that belong to his entity. But again, if both are filing, I think then obviously it's all for naught. Perhaps it would be wise, and I don't want to clog up the court's docket, but I don't know what kind of timeline Mr. Glazer believes he'll be filed or will have filed under, if it's a brief continuance of this hearing to allow him time to provide those documents and potentially file. And then if he does in the meantime, the court would be notified and be put on stay.
Well, I understand from plaintiff's standpoint, Ms. Powell, this is not a good position for you. You've done what you've been required to do, which is file the request for debtor's examination, appear, make requests to the court, and you're here ready to proceed today, and your client is entitled to the judgment that they've secured. So I understand you've done nothing wrong in this case. Mr. Glazer, I understand that the legal process can be intimidating to non-lawyers and people that don't understand exactly what's going on. I'm glad that at least based upon what you've represented, that you're hiring an attorney to help you, at least in context of bankruptcy. That's not this case, but it might help with this case. It does not sound to me like anything has actually been filed. What I'm going to do in the exercise of my discretion today is, Ms. Powell, I'm going to allow you to renotice this debtor's examination hearing. To the extent she renotices it, Mr. Glazer, your requirement, this is not a request, this is a court-ordered requirement, is to have all of the documentations to provide to Ms. Powell at the next hearing. Do you understand?
I do, Your Honor.
If and to the extent you have individually and as an entity filed for bankruptcy protection, Ms. Waltman will have let this court know, and it will come to me, and I'll have certain obligations that I have to undertake, and Ms. Powell will as well. But until that happens, there is no protection from any discussion of the word bankruptcy. You understand?
I do, Your Honor.
If we come back at a new hearing that's scheduled by Ms. Powell's office and you don't have that documentation, you need to understand that the court can treat that as contempt of court. Do you understand?
I do, Your Honor.
And while generally I agree with Judge Mertz in hindsight that probably this would be civil contempt. In other words, all I'm trying to do is force you to comply with the court's order to prepare documentation and give it to Ms. Powell. Even civil contempt can be punishable by jail. And you can be jailed indefinitely until you comply with my order if you don't comply with it by the time we come back next month. Do you understand?
I do, Your Honor.
Do you have any questions?
Excuse me.
I said by the time we come back next month. What I mean by is by the time we come back, when and if Ms. Powell decides to renotice this hearing. Ms. Powell, I'll leave that in your discretion entirely. Certainly, if you want to reach out to Attorney Larissa Waltman, I don't have any issue with that. I'm not requiring you to do that. But if you do and choose not to renotice, I'll consider the matter done. But if you do renotice, I'll let you do that at whatever date works for your office's time schedule and calendar. Do you have any questions, Ms. Powell?
No, Your Honor.
Mr. Glazer, any questions before we break?
No, Your Honor.
All right. See everyone at the next hearing then. Thank you.
Thank you.
Well, that was fun. Yeah, she was in here singing her songs and twirling and dancing earlier. All right, guys. I started early because I was hoping I'd be able to maybe stay on longer, but dag nabbit, I'm tired. And I know some of you are too. So let's call it a night. Let's call it a night for tonight, and we will reconvene hopefully tomorrow. I had such a great time with you guys, and thank you again, Linda Applegate. I am so grateful. I absolutely love my pennies and all of the other coins, but I love the pennies. Oh, be safe, Jerry. I hope everybody has an absolutely fantastic day. You guys are wonderful, and I'm so grateful to have you in my life. In all of our lives. You can't see her, but she's over there tapping her tail. Hold on. There. No, that was not a request. Quite the opposite. We get to close out the stream with Ava. Oh man, you're too sweet. Be safe, be well, sleep sweet, and much love.